We are saying open. We are saying open. SCGP.
Is what is the matter about?
No, file is not with me. They have not sold the copy also.
No representation on behalf of the petitioner. Is this matter for dismissal tomorrow? Yes, next.
Number 3.
Then counsel submits of the needful is done. List after service of notice.
Number 4. Shall I ready?
Then counsel submits in the course of the day. Needful will be done. If the same is not done, the petition shall stand dismissed without further reference to the court. Next.
Number 5.
No representation for dismissal tomorrow. Yes.
Number 6. Shivasanu, Karnataka.
Accommodations.
2 days time in hand. If you comply with the office objection, same. Or in all the cases, default order. Yes.
Interim order, yes.
Interim order earlier granted is extended. Yes, next.
Similar.
Number 7.
Same.
Same. 2 days. In this also interim order is there?
Yes.
Yes, interim order earlier granted is extended till the next date of that.
Number 8. Prashant and Board. Krishna Dhanvi.
Yes. Dismissal. Yes, tomorrow.
Number 9. This is Somapu.
Same. Yes.
It should not be.
In which matter? 8 or 9? Huh? 5.
1 week time not to forest the trustee of.
Serial number 5, same. A week's time, default order.
Yes.
Number 10.
9, what happened?
Number 9.
9, dismissal. Yes. 10.
Number 10. Shall I Bolma?
I am for prosecution, my lord. Needful has been done, my lord.
Then counsel submits as a needful is done. Post after service of notice.
Interim order, my lord.
Interim order, wherever interim order is there, don't write that. Wherever interim order is there, you have to look at the file. Interim order is there, extended. Yes. Yes, for dismissal. Yes. Next.
Number 12. Namdo Shidam.
1 week. 1 week.
A week's time, default order. Yes, next.
Number 30. Self-line party.
For dismissal tomorrow.
Self-line party.
In all that, no representation, but
Sharmila M. Patil.
she's there.
Yes. Sharmila M. Patil. Madam, submission ಮಾಡಿ.
My lord, a week's time, my lord.
Yes, a week's
My lord, a week's time.
Yes,
A week's time to comply with office objection.
Yes, next. A
Please.
week's time. default order.
Number 14. Rasi party.
The postal shara says that the respondent has left without instructions about it. Ascertain some new address and take out exception. Obviously, it would be no issue.
A 2 weeks time is granted. For taking steps. Yes.
There's an interim order in operation.
Interim order granted earlier is extended to that. Yes.
Number 15. Girish Nithat.
Yes, my lord. The office objection is regarding the title of the order sheet. Annexure J, my lord. The input order is in the title format, but annexure H.
1 minute. J is page number.
54, my lord. The daily orders are in a manuscript. The officer raised objection to file a title copy of the daily orders.
Because we can't read it.
But the issued order against which my IS rejected, I have come across this book, not rejection of me. application under order 7 to 11, that order is in the type department as an annexure.
No, you're not relying on this.
No, my lord, the daily orders are, I'm not relying on.
Then
the
why
order.
did you file it?
To show that my lord, the pending proceeding before the trial court, the office will raise the objection if I don't file the order sheet. That's why I filed. The input notice annexure H, my lord, page number 48.
Then counsel for the petitioner submits that. As far as the objection serial number 1 is concerned, on those proceedings is not relying concerning the submission of the counsel, office objections or overruled. This is matter for admission tomorrow.
Please, my lord.
Yes, next.
Please.
Seal number 60.
In respect of serial number 8, I appear for the petition in that.
It's already over. Now we are at 16. No. No case will be dismissed for non-prosecution on the first time. Court will give you a long rope tomorrow. Then if you don't come tomorrow, then it will. Yes. What do you want to say in that?
But in that, the respondent has been engaging counsel and obtaining NOC. On the
We'll
last,
see tomorrow. It will come tomorrow.
in that interim order of
If at all interim order is there, they'll extend. Yes.
Seal number 60. Creation open.
Appealing for respondent statement.
Yes.
In this
Because tomorrow for dismissal. Yes, next.
Seal number 70. Making headed.
Lord, yesterday's matter, Lord. No,
Yeah.
on my request, matter was posted today. Office has raised a further objection that annexure M certificate copy is not produced. Lord.
Annexure?
Annexure M.
What is annexure M is impure?
Improved.
And then if you not file a certified copy, then you have to ask for dispensation.
Got the certificate copy, my Lord, to permit. Since there was some extreme urgency, my Lord, yesterday.
We'll pass over, do whatever you want to do.
I will permit it to produce the.
Yes. Pass over.
Any more money? Seal number 80.
In this matter, in a matrimonial case, permanent aluminium was fixed at rupees 10 lakh. And thereafter, the husband did not pay the amount which is awarded by the family court. Thereafter, for recovery of the said amount, the wife has filed a recovery petition by way
You
of.
offer the petitioner.
I represent Proceedings and the Lords. He seeks tomorrow the matrimonial agent.
Tomorrow we'll take up no further adjournments. Please tell him.
Please.
I request you from council,
Chairman,
we shall
order
list this
will be
matter tomorrow. Interim order will be granted is extended till then. Tomorrow we'll hear.
Seal number 90. Alicia's name. Mrs. Puliwa.
After instruction, the respondent is already living together. And it next week, I will verify and.
It is submitted that the parties are living together. We'll get further instructions. This is matter on 5th of November. Yes, next.
Seal number 20. Santosh Kumar Ji, Rampur. If you are ready.
There is a delay of 62 days in filing the petition.
62 days. Yes. I number 1 of 2022 is filed to condone the delay of 62 days filing the petition. So when the RPS, considering the reasons stated in the accompanying affidavit, the delay is condoned. List is matter for admission. Yes.
Please.
Seal number 21. Seal number 21. Right, Kesa.
Password.
Password.
Control password. Seal number 22.
Petitioner,
Harsh Desai.
in this case, they have filed a vacating aid stating that a conditional interim order was granted to continue to pay on 4,000. Since we have not paid the 4,000 every month, they have filed a vacating aid. However, your lordship, the petitioner has brought the DD of arrears amount. Due to
What we'll do is we'll hear the matter itself. Why
Please,
this
please,
tomorrow? This is matter tomorrow. No
Interim order.
representation for the respondents. Interim order order granted is extended.
Meanwhile, we'll deposit the arrears amount.
Whatever it is, please do. Anyhow, tomorrow we'll dispose it of. Yes.
Interim order may be extended.
That's what I said. Yes.
Grateful.
Seal number 23. NR9.
Same order tomorrow, no representation for dismissal.
For dismissal, cell number 24, Sanjana Mr. Kulkarni.
Yes.
In this case, Lord, the petitioner has challenged the order of arrest warrant that issued in a matrimonial case where order was passed for restitution of conjugal rights. The provisions of order 21-32 do not.
Yesterday this matter was heard. This is heard
Yes,
yesterday.
it was heard. But now I have been told that the matter is settled and now they are living as living together.
Then I'll record that and close this. The
As far as that order which has been challenged, Lord, such an order cannot be passed because order 21-32 it makes specific reference saying that arrest warrant cannot be issued in case of restitution.
No, in this arrest warrant is not issued.
It is issued.
No, you just said that the notice in EP is issued.
No, my lord, it has arrest
Let's see
warrant.
that. Let's see that.
Yes.
Where is it? In that case, you will set aside this order
Yes.
and record that also that they are living together.
Yes.
Where is that?
Lord, on page number 64. Handwritten, Lord, issue arrest warrant to the JDR.
Please read what has been stated above.
Yes. It is only stated that he had been posted to different parts in India by his employer and he could not be able to attend on the last date of hearing. But he did not state any reason as to why he did not comply with the decree for restitution of conjugal rights. Third, objections to is rejected, issue arrest.
Yes, we will set aside this order.
Yes.
Please come. The present petition is filed, seeking to quash the order dated 24/2016, passed by the Family Court Ballari in EP number 4 of 2025. The respondent here, who is the wife, had filed a MC seeking restitution of conjugal rights. The same came to be allowed. Who filed, wife or husband? Wife had filed MC number
55 of 2014.
MC number 55 of 2014 on the file of the Principal Judge Family Court at Bellary, and the same came to be allowed by order dated 9th February 2015. Thereafter, she had filed the execution 4 of 2015. In the said order, the court had issued an arrest warrant, observing that the husband has not complied with the order passed by the court, where a restitution was ordered. Next paragraph. Let counsel appearing from the petitioner, husband submits that the court is not, there is no such provision of issuing arrest warrant for disobeying the orders passed in a restitution of conjugal rights petition. He submits that the court had gone beyond the jurisdiction and passed an order. Next paragraph. Let counsel appearing for the respondent, wife submits that now the wife and husband are staying together, and no further orders needs to be passed in this petition. Next paragraph. Though the parties are staying together, still the order that is passed by the learned judge that's impugned herein is beyond the scope of the powers conferred on the court, and there cannot be an order of arrest and the execution of a decree of restitution of conjugal rights. In that view of the matter, the order dated 24/4/2016 is set aside and the petition is allowed. Next matter.
Cell number 25,
Respondent number 4, my lord.
No?
Appearing on behalf of respondent number 4, my lord.
Go for the respondent.
Please. I'm a formal party, my lord. Appearing on behalf of KSRTC, my lord. As the present petition is in driver, my lord. They have challenged the compromise decree, my lord. The present petition against the respondent number 1 to 3, my lord.
Please come. As there is no representation on behalf of the parties, this matter was directed to be listed for dismissal today. Today also, there is no representation on behalf of the petitioner. When accounts for the respondent is present, it appears that the petitioner is not interested to pursue the matter. Accordingly, the petition is dismissed for non-prosecution. Yes, next.
Number 26.
Worship, the party is not in contact, and the import service, the MC case filed before the trial court has been, it's shown that it has been disposed of.
Oh, the MC is disposed of.
Disposed of.
Then counsel for the petitioner submits that the main MC itself is disposed of. There's nothing service or consideration in this petition. Accordingly, dismissed as instructions. Yes, next.
Number 27. Mr. Bambari, you are welcome. 27. Mr. Ukeri.
As there is no representation on 21/10/2024, this matter was directed to Mr. today under the caption for dismissal. Today also there is no representation. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Yes, 28.
Number 28. Santosh Rao, tell us please.
Huh? What needs to be? What a why is it listing listed? Memo for reporting death of furnishing of PP so and so for R1 R10. Memo for reporting death of R5. Reporting death of A so and so. Take out this memo. Memo for service of notice to R6. I said sufficient. What about then all these LRs have to be brought on record? Should file an application bringing the LRs on record. Show this to her. Pass over. Look at it. What are the objections? Look at it. Yes. Next matter.
Paso. 28. Number 39. Italia. Company. Correspondent for
on 21/10/2024, same order. Yes. Next. It is submitted that the memo is filed stating that the respondent herein has withdrawn the main MC itself. Hence, hence the petition was permitted to withdraw this petition. Memo is taken on record and the petition is dismissed as withdrawn. Yes, next.
Number 31. Delpati Ampat. Delpati Ampat, number 31.
Right from 17/10/2022, the matter appeared on several occasions, and at the request of the petitioner, my matter is adjourned for taking steps. This is a RPFC of 2022. When the matter came up on 23/10/2024, as there was no representation on behalf of the petitioner, this matter was directed to be listed under the caption for dismissal on 24/10/2024. Even today also there is no representation on behalf of the petitioner. Accordingly, the petition is dismissed for non-prosecution. Yes, next.
Bill number 32.
PF today paid.
Yes,
PF,
paid.
want of PF arrested and the want of PF is terminated.
Oh, it's partly, there was no representation. Where is Mr. Ramesh?
Ramesh, I generally. Bill number 32.
As per the office note, the petitioner has paid the process today. Issue notice to the respondents, delete from the caption for dismissal. Yes.
Bill number 33. Yes.
Huh?
I request for tomorrow.
Why?
Due to some medical emergency, consider under for the problem.
Tomorrow, at the request of learned counsel, the petitioner, delete from the caption dismissal. Huh? This is 32 or 33? 33.
Yes.
What happened? 32 you didn't write? No, not dismissal. That 32 he has paid the process, delete from the caption dismissal, and yes, 33 is asking for time. Yes. Yes, next.
Bill number 34. Yes.
In the first petition, my lords, the advocate for the petitioner has filed a memo for retirement, my lords. I represent the respondent. And in the connected matter, my lords, I seek for 2 weeks' time, my lords, to comply with the office objections.
Where is the counsel for the petitioner? Give that 34.
Section CID. Bill number 34.
Where is that memo for retirement? The memo of retirement is filed to the council. Shreya S. Kataki Mat, saying that it is stated that he has issued a when she has sent they don't even tell the office shouldn't have accepted this kind of a memo. They don't even say when it is when they have sent the notice, nothing. On 11/7/2024. Please read that notice to the petitioner. The land council appearing for the petitioner in RPFC number 1000001 of 2024 submits the office objections will be complied within a week. Yes, this is matter of service of orders. Yes,
Much obliged, my lord.
Bill number 35. Is he ready? Shall I play?
The husband petition challenging the interim order passed by the trial court, wherein your lordship ex parte order has been paid, made.
Ex parte order?
Ex parte order has been passed on an interim maintenance, your lordship, to pay the monthly 7,000. Now I am just seeking to the one opportunity for the petitioner, where we will also produce
No,
our
why you
assets and.
didn't appear before the court?
Please, it's challenging the ex parte interim order, Your Lordship. Now we are seeking, at least he is ready to.
No
pay.
notice is given to you.
Please, Your Lordship. No notice is given to me. Your
Where do you
Lordship.
get that?
At first instance, I order and I was passed, Your Lordship. It was an ex parte maintenance order.
What is the
Now
grave
he's
urgency
paying-
for the court?
Now he is paying regularly the maintenance.
No, that's true. What is that urgency for the court? They should have given notice to the respondent and then passed an order.
But after that, when he had an objection, he did not seek any prior to that he is going to hear the matter, Your Lordship. Now the matter is posted for arguments, Your Lordship. And he is regularly
What
paying
is
the
your
maintenance
income?
amount.
Please, Your Lordship.
What is your income?
He is working as a junior engineer in Bangalore, Your Lordship.
Then how much is the income?
He is getting 35 to 40,000, Your Lordship, monthly. Now he is only seeking, he is ready to give the maintenance amount till disposal of the application. Please, it may be reduced to the 5,000 and where opportunity will be given,
What fair opportunity now?
he will produce his assets and liabilities.
No, that's
And
what.
he
That's
will
what.
also produce the respondent's
7,000 is a reasonable amount. No, it's at the stage of arguments. Why should we again start everything? We can understand like if it is some exorbitant amount is granted, then 7,000 less. Any court will not grant less than that even after all that adjudication is done.
His thought is now interim maintenance itself is passed at 7,000. It may get higher at the time of a final maintenance order.
No,
They
then
themselves also-
now you're contesting the matter. Now you're contesting the matter.
He's
No,
appealing.
the court will record. Now I'll record that because already the matter is at the stage of arguments without going into the merits. No, without going into the merits of the matter, this court is confirming this order, but the trial court has to independently deal with your final maintenance.
Himself have admitted he is earning 6 lakhs per year, wherein his income is, Your Lordship, 40,000 on hand, wherein he is living in Bangalore. She is also well educated and she has the property. So I'll also produce his,
So the main application will be decided. No?
Please,
That
please,
you can do it. Yes.
One more submission. The court before which it is filed is Karnataka, Your Lordship. It comes under Udupi. So this bench doesn't have any jurisdiction.
Since he is residing in Bagalkot, Your Lordship.
Not
No,
residence
where is
court,
the family
Your-
court? That's what.
The order was passed by the Karnataka trial court.
Yes.
Then that has to go before the principal bench.
Please, Your Lordship.
Then how can it be? How can you file this?
Sorry. Since he was residing in
Then it
Bangalore.
has to be dismissed on the ground.
Since he was residing in Bangalore.
No, it's not about where you are residing. The court will not get
Please,
jurisdiction.
I leave to this honorable court.
So then we'll record that and
Please,
dismiss
Your
it.
Lordship.
One more submission. Lordship permission. Having matter report out for Your Lordship. I may be permitted.
Yes. The present petition is filed, agreed with the orders passed by the family court, that's by the senior civil judge at ACJM Karkala, ODP, dated 25/2/2022. The family court, the senior civil judge court, civil judge at ACM Karkala is not within the jurisdiction of the High Court of Dharwad. Accordingly, the petition is dismissed, and the petition is at liberty to move the appropriate court.
Please.
Yes.
Cell number 36. Citation period. Citation period 36.
As there was no representation on 23/10/2024 with HMB. So the right know that there is no representation. Then only it will be listed for caption dismissal. If the right tender or not, there should be there. As there was no representation on 23/10/2024, this court had directed the matter to be listed under the caption for dismissal. Today also, the matter is listed with the caption dismissal. There is no representation on behalf of the petition. It appears the petitioner is not interested to pursue the matter, accordingly dismissed for non-prosecution. Next,
Seal number 27. DB Patna. Number Vikalav.
on 7/3/2023, at the request of the land council, the petitioner 2 weeks time is granted to comply with the office objections. Again on 7/12/2023, another 2 weeks time is granted. When the matter came up on 21/10/2024 before this court, neither the office objections or complaint, nor the counsel for the petitioner is so what is there?
Yeah.
All these no, you can't. The office objections are not complied with 24/24. Not this, don't write this matter under the capital dismissal. That is not the order. It is if the office objections are not complied with 24/10/2024. Without further reference to the court, the petition will be dismissed. That's the order, but you wrote something else in this. It's not in dismissal. It is from the caption dismissal. And this is matter next week on 4th of November.
Seal number 38. Here product take a book.
On 23/10/2024, as also representation on behalf of the petitioner, this matter was directly registered under the caption for dismissal. Today also there is no representation. It appears that the petition is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Yes.
Seal number 39. Rajshekar Gucci. Sajid Aid. Mudwala.
This matter I appear for respondent.
Why the councils are not interested, they are not appearing before the court, and why they are getting the matters to be dismissed for non-prosecution? Very strange. The matter came up on 23/10/2024. Council. Huh? Yes.
I agree with you. This petition is by the husband against the order of the court below that granting maintenance of petition at 8,000 to the first petitioner. And
You can take a break. We'll just look at the order.
yes, the reason is the issued order.
No, you can take a minute. First petitioner is,
First, wife Milord, and the second one is the daughter.
how old is she now?
Now, 12 years.
12 years.
12 years. So for both of them, 16,000 is granted.
Yes.
What is your income?
But the petitioner Milord is admitted Milord, he is working as Milord, the contractor Milord. He is Milord, there is no permanent job as such Milord. He is working as a broker Milord, where he will supply the bricks and sand to the construction.
No, what has been recorded by the court while granting this maintenance?
Milord, at page 8, para 70 of the court below Milord.
Please read it.
In page 34, Milord.
Please read it.
That as per the petitioner, the respondent is doing business of four-wheeler and two-wheeler vehicles and the modification and alteration as per the demands of the customers and earns more than 4,000 per day. By relating to the income and occupation of the respondent, the petitioner has not crossed any document. So, whereas the respondent in his objection has contended he is working as a broker of building materials like sand and bricks and earns 7,000 per month. But to prove said contention, the respondent has not laid his evidence and also not marked any documents. Hence, looking into the raising prices of essential commodities in the market.
So there is no evidence on record. What is the income of the petitioner? But what they are, except what you have said so. Then on what basis the court can grant 16,000 when the person says he's earning 7,000 per month?
Not 7,000.
That's what he said.
Per day.
Huh?
Per day.
No. Your case is 4,000 per day. According to him, it is 7,000 per month. Nothing has been placed on record to show that he's earning this 4,000 per day.
And further, my lord, in the Domestic Violence Act, under section 12, my lord, he is already paying 3,000 rupees, my lord. That is also not considered by the court, my lord, while granting.
Then both of you file your respective statement of assets and liabilities. Then basing on that, we will see. Both the parties are directed to file their respective statement of assets and liabilities as per the judgment of the Honorable Apex Court at Rashish vs. Neha. This is matter on 19th of November. Yes. Delete from the caption for dismissal.
Number 40, should be 9.
Huh? You want to withdraw the petition? Take the memo. A memo is filed stating that the petitioner has become infractious and the petitioner wants to withdraw the same. Accordingly, the memo is taken on record and the petition is dismissed as withdrawn. Yes, next.
Number 41, Reversing Party. SCP.
I appeal for the petitioner.
Yes.
So, facts in brief are that, Your Lordship, I am aggrieved by the order passed by the respondent number 1, which was confirmed by respondent number 2, who is the Excise Commissioner of Karnataka.
Respondent number 1 and respondent number, yes.
The facts in brief are that I have been running a CL2 wine shop at this place since 2014. I was granted a license much before that. However, in the year 2014, I shifted my place of business to this place. Now, the admitted facts are that, Your Lordship, I have been running this business at this place since 2014. Then, in the year 2020, January 2020, a school came up in the same vicinity, which is Maulana Azad English Medium School. And in July 2020, Office of the District Minority and Welfare was established in the same vicinity. Then in the year 2023, May 2023, there was a divider on the road which was demolished by the municipal corporation. Now on the basis of these facts, the respondent number 1 issued a notice to me stating you fall under the objectionable place under the excise rules and therefore your wine shop has to be shifted. I appealed before the respondent number 2. My appeal came to be dismissed.
So what do you say that once you establish a permission is given to you for running a whatever the shop, so no other establishment should come around, and because you are running from a long time, He should be permitted.
No, Your Lordship, I am protected by an amendment of the state government
What is that
to the
amendment?
Act, the typed copy of which is filed at page 31, Your Lordship. These rules may be called the Karnataka, these are published in the Gazette, Your Lordship. I am reading an extract of the Gazette. Title and commencement. These rules may be called the Karnataka Excise General Conditions of Licenses Amendment Rules 2016. They shall come into force from the date of their final publication in the official Gazette. Amendment to Rule 5. In the Karnataka Excise General Condition Licenses Rules 1967, in Rule 5, in Sub-Rule 2, after the second proviso, the following provision shall be inserted. Namely, provided also that nothing in Sub-Rule 1 shall be applicable to the licensed premises within a distance of 100 meters from any religious or educational institution or hospital or any office of the state government or the central government or local authorities renewed or existed as on 1st July 2016. So, I am taking shelter of this amendment to the rules. Your Honor.
What is meant by this rule?
No, that rule is only say, there is an exception. As on the date of 2016, both the objectionable things as well as the shops should be existing. As a one-time measure.
That means if he has a license by 2016.
Please.
2016.
Please.
So this rule will not apply to him.
Yes, as a one-time measure, legislature is intended to give an exception to something. That rule has not questioned. That to get the benefit of that proviso which is added to amendment, the condition precedent is that the licensed shop should be existed at a place and objectionable place also should be there at a place. Even if the distance is far below the statutory intended meters, then it can be protected. Yes, prima facie rules looks like arbitrary.
No, there absolutely no application of mind in making this kind
Yes,
of rule.
yes, I go down to this one. This is a mistake on the part. Maybe it is a legislature. I can't call it as a mistake. The legislature intention. One time measures, there is exception is given. But this proviso will not come by no helpful to my learned friend is concerned.
No, let's read it again.
Please.
Provided
I'll
also.
read one second. Provided further, Deputy Commissioner of Excise may grant license to locate.
No, read from provided also.
Provided that, so I will read the entire last two itself. The Deputy Commissioner of Excise shall, after making in such inquiry.
No, I am looking at the rules 2, amendment to Rule 5. From there I am reading.
So, please.
Page number 32 of his papers.
Please.
No, every year you have to renew your license.
Yes.
Whenever you are renewing your license, all those rules will be applied, like the no objection, whether they're within the vicinity, whether there is any.
No, that would not be correct.
No,
For the reason that the amendment says.
Forget about amendment.
Please,
amendment will go through later.
Please.
Now, every year you have to renew your license.
Please,
While renewing your license, there are some formalities to be complied with by you.
Please,
In that, is it not one of it, like no objections and the people living around?
No, for renewal, that is not a condition.
What are the, for renewal, what you are supposed to do? Which provision deals with renewal?
May request compilation.
Take that.
The licensing of the various liquor shop and renewal is governed under Karnataka Excise Control Conditions License Rules 1967. Section 5 is the relevant section. The provision which my learned friend is talking of is at case 3 of the provided also. Nothing in the subsection rules shall applicable to the licensed premises located within the distance of 100 meters.
No, in this compilation you are reading?
Yes, in the page 3, running page 3 of the rule, start with the provision. That is the amended provision.
Provided that.
Also, nothing in the subsection rule 1 shall be applicable to the licensed premises located within the distance of 100 meters from any religious educational institution, hospital, or any office of the state government or central government or local authority, renewed or existed as on 1st July 2016.
No. By this proviso, the intention of the legislature is that on 1st July 2016, if this person is having a license, if there is any other, that he is exempted from Rule 5.
If any objectionable thing will come in that way, it is exempted.
Exempted.
Yes.
No, he is having license even prior to
But
2016.
the objectionable thing was coming to picture after 2016. As on the date of amendment, both should be existing. My most approvable submission, reading of this.
No, do you, are you?
Otherwise, madam.
No.
My last, please.
No, that means after, this particular school is established when?
My lord, the shop was shifted in year 2014. The government school was established in the year 2020, and the government office was established in the year 2009. Two objectionable.
So according to you, by 2016,
please.
There should be a license. There should be that prohibited whatever religious or educational institution.
If, as on the date of, for example, when the 2016, my shop is being established, and within that meter, within the prescribed meter, if the school is existed, education institution is existed, as per the provision of the one-time measure, it is exempt.
Where do you get that one-time measure?
One-time measure means it is a renewed or existed, renewed or existed as on July 20, 2016, not subsequent that.
They are speaking about a license premises.
Please.
Located.
About, before that, nothing in subsection Rule 1. Rule 1 provides for which are the places the shops should be maintained distance. That is a proviso, that is an exception to the proviso Rule 1, sub-rule 1. I agree with the sub-rule 1. Sub-rule 1. Sub-rule 1 says.
How do we construe that rule itself?
Otherwise, madam, if it is being implemented, it will defeat the entire object.
Why did you make the rule then?
That has been one time.
They have to say
that
has to be, the rule has to be removed from the book, from the rules. And you cannot interpret in the manner in which you want.
As an officer of the court, madam, I go down to the observation made by the but that is a statutory interpretation. Literally, what it has to be considered, it has to be considered. The rule 1.
It has to be read like this. As on 2016, if a person is having a license, and thereafter also whatever that comes
then my respectful submission is, then the power of the deputy commissioner under subsection 4 will be going to be.
By making this rule, that's what you made that Rule 5 itself as redundant. By making an amendment to that, then 5 itself has become redundant.
My instructions are that, madam, it is a one-time measure, it has been done.
One-time measure, it is not from where and how the officers say. It should how we look at it. Then he is entitled for that.
I will read the entire section for my.
Yes.
The entire case, madam, as my lordship said, entire case depends upon the interpretation of the provision, not more than that. He is claiming the benefit under the provision.
A person,
please,
who as on 2016 a person's status,
yes,
by after 2017, why there is a difference? No, probably it is intended for somebody, for a particular person. So one time opportunity. How can the rules be like that?
That I can't make any.
No, I'm not even expecting you to make any comment or submission on that.
Please.
You cannot.
Please. But if that is the case, I read the subclass 4 also,
yes,
which is important for me. The deputy commissioner may, by order after giving a license, an opportunity of being heard, direct the such license to shift the location of any shop. Next, with a view to security, convenience, morality, tranquility, decency, safety of the public, where after the license, religious institution, kindly mark this now, where after the issuance of a license, any religious institution or education institution established or any office of the state government, locality authorities are opened within the limits specified in these rules. Even if I running a shop at a place, subsequently if the objectionable things was established there, then also every year.
No, the court can understand the noble cause under Rule 4 and 5. But why this amendment? If that is what you want.
Yes, madam. I cannot go behind the amendment. Yes, the reading of the amendment definitely will protect the someone which existed in the year 2016. My statement is that amendment classification made by the amendment and the other things is based prima facie example. But
Why don't you question this rule?
if the rule is questioned, madam, then I have
Why
no
don't you
objection.
question this rule? Then it will be of much benefit to you.
Rule 4, Your Lordship.
Rule of provisional.
Amended rule.
Your Lordship, amended rule is in my favor.
Hmm?
The amended rule.
Their interpretation is not in your favor.
Your Lordship, their interpretation.
What they say is, as per the rule, as on 2016, both you should have a renewed license, and there should be that the objectionable, either the religious institution or a school, should be existing as on that day. In that case, you are exempted. If it comes at a later point of time, then you are not exempted, is what, according to them, is a purport of that amended rule.
My humble submission will be that.
You should say that, you are also entitled, like, there can't be a discrimination of this nature.
For the reason that, Your Lordship, one, I am placing reliance on legal interpretation. On plain reading of this provision, amended rule, Your Lordship, it does not say that the school, college, hospital or religious places coexisted
Then
as
if
on
you
this
look at the amended rule, then you look at 4.
Lordship, in that
These
case,
two are independent. There is no harmonious construction of these two.
they are in contradiction, Your Lordship. The rules made by the state are not only in contradiction with each other, but now they are.
So no, these rules were made, this amendment was in the year 2017.
This was in
2016.
So till now, this is not, nobody has questioned
No,
this.
nobody has questioned.
Just for
Have you filed your objections?
This I know.
Please file your objections and tell the court what does really
Please,
this
object,
amended
what is the
clause.
objection? That I know.
Then so that we will be able to pass an order on that.
Please.
The council appearing for the petitioner submits that on the ground that educational institution has come up within the vicinity of the licensed premises. Who are the authorities?
Yes.
Deputy Commissioner Excise and the Excise Commissioner.
The excise commissioner had rejected the case of the petitioner, and against that he preferred an appeal. Appeal also came to be dismissed. Agreed thereby, he is before this court by filing this writ petition. Land Council had relied on the amended Rule 4 of the Rule 5 of the Karnataka Excise within brackets General Conditions of License Rules 1967. Relying on the said rule, Land Council submits that if he is having a license as on 2016, even if there is a religious institution, there is any other, the no prohibition under Section 5 will apply to the petitioner. The same is denied by the learned Additional Advocate General, stating that that it is only a one-time. He submits that as on the cutoff date, there should be there must be a license, and at the same time, even that religious or the educational institution must be existing as on that day. It will not apply to any other. It will not apply to the subsequent years if that institution or the religious institution or the educational institution comes up at a later point of time. Then, in if they have come up at a later point of time, then Rule 5 has to be applied, and the amended rule will not come to the rescue of the petitioner. On the face of it, this court is not able to understand the amended rule and the original rule that still remains to be in the still remains to be in the rules. On the face of it, there appears to be a contradiction between the two. The respondents shall file a detailed counter affidavit, detailed objections in this regard. Rest this matter.
10 days time.
This is matter on 12th of November.
Please read. Great.
There is an absolute order of protection to me, Your Lordship. Till further
The
order.
interim order earlier granted is extended till then.
Even this rule was called before my instructions are. This rule is also called before the High Court committee, one of the committee. One of the committees also suggested. So this will give the protection to someone. You withdraw that rule. So there was some observation.
That there will be a lot of, contradiction.
Yes,
When the purpose itself is,
very-
and we can understand that the 5 you are completely removed, 5 rule 5 remains to be there. And you go,
Yes.
and you amend some, by way of amendment, you bring some clause which runs contrary to the main rule itself.
Main rules. That the intention may be as Millard said. But if you use this such type of interpretation, like entire section 5 become redundant. Even after the establishment of that 5 become redundant, that
Become
cannot be
the-
enforced.
No, it has to be, no, either that amended rule should be there or the original
Please,
rule should be
please,
there.
please.
But both cannot exist in the
Please,
rule book.
please.
Yes,
Yes.
yes.
Seal number 42. Saurabh Sandu. Saurabh Sandu. Seal number 42.
Yes, this is also a dismissal. Yes. As there is no representation on behalf of the petitioner on 23/10/2024, this matter was directed to be listed today under the caption for dismissal. Today also there is no representation. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Yes, next.
Seal number 43. CCID.
Yes.
Serial number 43, Your Lordship. 2 weeks time to complete the office objection, Your Lordship.
Or you want 2 weeks time? A week's time is granted for complying the office objections. Default order. Yes, next. Delete from the caption for dismissal. Yes, next.
Seal number 44. Disseminate.
As there is no representation on behalf of the petitioner, this matter was directly listed in the caption for dismissal to the same as so dismissed for non-prosecution. Yes.
Seal number 45. Mr. Sangi.
Same 23/10, this matter came out. Directly to be listed today, dismissed. Next.
Petition matter. Seal number 46.
Defendant's petition. Application under 7 Rule 11 has been dismissed. But my contention was that suit was barred by limitation. Suit is all for recovery of damages. Initially, tender work was allotted to me by the Ilkal CMC for installation of underground laying of sewage plant in the area. Thereafter, work order letter of acceptance was issued on 20th/9/2010. 18/10/2010, defendant and plaintiff entered into contract. Time limit was for the conclusion of the contract was 18 months. Thereafter, on 26/4/2012, my contract was terminated. That was called in question before this honorable court in writ petition. There was an order of status quo.
WP is when?
2012.
When was the status quo order was when? When was it disposed of?
Disposed on 11/1/2013.
11/1/2000. What is the observation?
Observation is to I have got alternative. I have got other remedy.
So till 11/1/2013 there is status quo.
There was a status quo.
Thereafter?
Thereafter, I preferred writ appeal. Minutes on writ appeal was dismissed on 15/2/2013. Thereafter, I filed a suit in OS number 130 of 2013.
130?
Of 2013. Now it is renumbered as OS number 95 of 2020. And another suit is filed by me is OS number 19 of 2015. Thereafter, present suit was filed on 9/11/2016. From the date of dismissal of my writ petition, suit is filed after 3 years, 9 months, 29 days.
What are the suits filed by you? What is the prayer that you sought?
In my suit was damages. My suit for recovery of damages since in lieu of termination of the contract.
95 of 2028? Take that.
One 30 of 13 is challenging the termination order.
So you have a cause of action to question that it is the declaration of unilateral termination is bad in the year 2020.
I have filed in the 2013 itself.
No, another is OS number 130 of 2030, renumbered as.
Renumbered. It is. Now it is before commercial code, so it is renumbered. And another.
So what is the relief? No, what they saw?
They are seeking damages of rupees 14 crores, 44 lakh 78,730.
Let's look at the plaint.
Please.
No counterclaim is filed in your suit.
No. Plaint is at in page 43 methods. After the wakalat.
Forty-three.
After wakalat. After wakalat. Their case is that in summon, this I will tell you. Their case is that after termination of my contract, they allotted to retendered it and given it to some other person. And after the work is done from that contractor, they reassess the damages, and thereafter this suit has been filed. This is their sum and substance of the. So
according to them, cause of action occurred to them when they have reassessed.
Reassessed it.
Not from the date of cancellation of the contract.
Not from the date of termination. Is very specific from the date of termination.
Now please come to the impugned order.
Please. Impugned order in internal page 4, paragraph number 7.
Page number?
Internal page 4 minutes.
What is the running page? Running page.
Running page. 13 minutes.
Yes.
Reason.
Small order, let's read.
What?
A small order will read the entire order.
Yes, entire order. Along with the facts note. First paragraph.
Yes.
First paragraph, this is an application filed under by the defendant under Order 7 Rule 11D, read with Section 151 of CPC, seeking rejection of the claim as being barred by law of limitation. In support of the application, the authorized signatory of the defendant company has sworn to an affidavit stating that the plaintiff and defendant company entered into a contract for the work of supplying and laying the sewage network, construction of FAL type STP of 8.0 MLD capacity, and to effect the improvements in the urban drainage system in Ilkal town. The plaintiff herein had unilaterally terminated the contract by notice dated 26/4/2012. Immediately, the defendant approached the court with a suit for permanent injunction, but it was unable to get an interim order. Later, defendant filed a suit for damages for illegal termination of contract in OS number 19 of 15. But the fact remained that the plaintiff had unilaterally terminated the contract on 26/4/2012. However, the plaintiff has filed this suit for damages on 9/11/2016, which is after 4 years, 198 days, which is hopelessly barred by law of limitation. Hence, he has sought to reject the claim. The plaintiffs have filed their objections to the application, terming the application as not maintainable. They have contended that the suit is well within period of limitation. The contract was terminated as the defendant had abandoned the work totally, and for their breach of essential conditions of the contract. The defendant has not raised the issue of limitation at the earliest point of time. The question of bar of limitation is a mixed question of law and fact. This issue cannot be entertained at this stage. The plaintiff determined the damages cost and interest payable by the defendant by its order dated 9/6/2015. The cause of action arose after the expiry of 15 days from the date of notice. Hence, the suit is well within law of limitation. Hence, the plaintiff have prayed to dismiss the application with the cost. Heard both sides, reduce the entire rent file with due care. The following points arose for my consideration. Whether the plaintiff is liable to be rejected as being barred by law of limitation. What order? Finding is negative. Point number 1. This is a suit filed by plaintiff for seeking relief of damages from the defendant.
Yes, what do you say?
My lord, facts to be clearly stated. A contract was given to me with a specific time limitation to complete it within 18 months. We paid him advance mobilization fund. We paid him mission development plan to him. He did not complete it, despite giving extension. So it was terminated. And in termination of that, as per the agreement, original agreement, there is a clause.
According to you, which is the article that applies for filing this suit for the damages?
That suit for damages is balance of work. Balance of work. He left the work unfinished.
No, that's what, we'll just look at that article.
Pardon?
Article. Article?
55 minutes, according to the.
That is the limitation, my lord. That is my statement of objection is kindly given. I have filed it in detail, and his contention is that, Your Honor, facts to be stated is very clear. We filed a suit for cancellation of termination order. Cancellation of termination order only is not there. And because of performance guarantee of more than 7 crore in a junior civil code, therefore it was challenged at that time. Then earlier that he had filed a petition. The petition was dismissed. There is no prosecution, we will not give it to go to the proper court. He filed an appeal. Appeal is also dismissed. Then he filed a suit. He did not get proper court of appeal because all the prayers were not called for. That was challenged before the honorable court and ultimately issued the judgment. Then he sought an application before the original suit, made the request for the honorable court to file the damage suit separately after the disposal of that suit. That is the permission was granted by the court. So,
to whom it is granted?
he applied. The contractor applied for the original suit, applied for the grant of relief to seek damages separately because he did not claim it in the original suit for the injunction.
No. Now the issue is, now from the date of termination of the contract, your cause of action starts. Number 1. 1 minute. Number 1, that is the date. The next one is when there was the writ petition, there was an order of status quo. There was an order of status quo in the writ petition.
It was dismissed.
No, I'm telling you about the limitation, that's in your favor. What I'm trying to say is in your favor.
Yes,
now, because of that pendency, that time in between, that also that you are exempted, that time is exempted. Whatever, whenever, till the time the writ petition or the writ appeal is pending before the court. So the limitation starts running again from the date.
The termination order, as per the original agreement, there is a clause stating that balance of work, if he has a terminated contract, balance of work has to be bought at its cost. Balance of work, he did not complete the work. That was terminated. He did not do the balance of work. Then I have to assess the balance of work. Then new cause of action started. And as far as the date concerned, my lord, kindly note the date, my lord, because according to him, termination of order dated is original agreement. There are 2 agreements now. The damage of 14 crore is demanded on basis of the second agreement, which was conducted by the third party for completion of the balance of work, which he did not pay. And in the termination order, in the original agreement, it is a specific clause that if he doesn't do the balance of work, it can be done by the employer and recover from the cost of the contract. So it is a substantive.
So according to you, Till the second contractor completes the work, you have to wait.
No, not estimated, we estimated.
And you have to seek damages from
Estimated,
them.
then we gave a notice to him. The date of notice, my lord, at my statement of objection is there. 18/3/2015, my lord, we gave a notice to him. There is a document approved in that statement of objection.
Why the time you have taken from the date of termination of the contract till that notice? Whenever you give a notice, that's not the cause of action. Your cause of action will start running from the day you terminated the contract.
The petition taken by lord, the article wherein.
Please look at Article 57.
The limitation period which
50? 55.
55 UI. When the contract is broken, the limitation act, my lord.
When the contract is broken,
55. When the contract is broken, or there are successive breaches, then the breach in respect of the suit is instituted occurs, or where the breach is continuing when it ceases. Even though original agreement ceased, the cause of action continued because balance of work was not done. And the notice of the Honorable Court agreed to notice that I have not made damages after breach of contract of the original agreement. I have demanded the damages in respect of the balance of the 14 crore rupees.
No, you have ascertained this is the amount that has to be spent for the remaining work, and you have given the contract to a third party. So, as on that day, you have ascertained what is the amount that as damages. That when did you give the contract to the second person?
Second person is my lord. On 26th of February 2014, my lord.
26th February
14. Today I have
26th February 2014. 2014.
This is the second agreement.
So, when is the suit filed?
9/11/2016.
9/11/2016. 9/11/2016. Then in that case, if that date has to be taken into consideration, then it will be within the limitation.
First date has to be taken.
Come to 55 again.
Yes.
No, read it again.
Yes. When the contract is broken, starts from the when the contract is broken.
No, first of all, your contract is terminated.
Yes, sir.
Now you are liable for damages for the remaining contract that has to be completed.
Second.
Now, that can be determined by issuing a contract to the other person by determining what is the remaining work, how much has to be done.
Yes.
Then they have given the contract on 26 February 2014.
My lords, in that event, my lords, 3 years, they had ample opportunity. Because my tender was terminated way back in year 2012. And from that day.
And you were also pursuing the litigation.
Yes, even after my lords, time from the where writ petition was dismissed is taken into consideration. From then also it is 3 years, 9 months, 29 days. And from the dismissal of my writ appeal is 3 years, 8 months, 22 days. Even after dismissal of my writ appeal, there was no interim order in the writ appeal, though. But even if that date is also considered, from then also it's 3 years, 8 months, 22 days.
He was telling about a clause in the agreement.
There is no clause. Even as you, may I pass on this?
He was referring to the clause. Just now you referred. With regard to how, if you fail to complete the work, what is the procedure to be followed? There's a clause in the agreement. That's what he referred to. Which clause is that?
Yes, sir.
Passover? Passover?
Yes, ma'am. My lord, both have directed to submit copies of the agreements, both agreements. Today I have given to Monitor. That agreement, I will have to refer. Because in the contract, it has to come back. Therefore,
This is matter on 6th of November. Yes.
Number 47, number 34.
respondent number 1.
Today, only that's on the PA.
Yes.
Petition by the judgment number 19.
Hmm.
The suit for partition and separate possession and also for declaration that seal deeds are not binding on the plaintiff.
What is not binding?
Seal deeds are executed
Executed.
by their father and brothers in favor of the petitioner and also other defendants, because the properties have been sold by their ancestors. Now after the seal deeds, the sister has filed the suit only to overcome the seal deeds. And collegium, according to me, that is may not be necessary to consider this petition because
What is the impugned order?
impugned order I filed IA Order 7 Rule 11 for rejection of the plaint.
Rejection of the plaint.
Rejection of the plaint.
On the ground?
On the ground that it does not disclose the cause of action against the petitioner.
You are a subsequent purchaser?
No, I am the first purchaser. I am the
The
first.
purchaser from the family?
Yes, madam. All the family members.
Your defendant number?
19, 19.
When did you purchase the property?
Purchased on 27/7/2006.
27/7/2006.
6. A scheduled property.
When is the suit filed?
36/2016. After lapse of.
According to her, she is entitled for the share in the property.
No, I am not saying that she is.
Not you. That's the case of the plaintiff.
Please.
That she is entitled to the share in the property.
Of course, not even. Being a co-person, she can be entitled, but my submission is, the suit is filed after lapse of 10 years.
So what is her age as on the day?
Filing of the suit. She is the major.
Where do you get that?
51 years as on 2016. She filed a suit.
Let's see the plaintiff.
Please. Description of the suit property is.
Where do you get the plain?
Plain page at page 20 starts not the entire cost title. The awardment starts on page 23. And 24 is the
Your defendant number?
19.
And remaining are the family members?
No, some of the defendants members also family members and other defendants also the purchasers of other suit properties, because there are.
You purchased from whom?
From the defendant number 1.
Defendant number 1.
Yes.
Who is the father of this lady or brother of
Yes.
the lady?
No, father. Defendant number 1 and 2, 4 to 7, and 12 to 18. Not I purchased it.
You purchased from defendant number 1 to?
1 and 2. And 4 to 7.
4 to 7.
And 12 to 18.
Yes.
Yes, scheduled property.
How many? What are the properties?
The properties are.
Please come to that schedule.
Yes. Page 36 is the schedule A. I have purchased not. Schedule B, schedule C, schedule D.
You purchased A.
Please.
You purchased A.
Yeah.
There are 4 properties.
Yes, ma'am. There are 7 properties.
No, in schedule A there are 4.
CTS.
4, 5 also there. 5, 6, 7.
7 properties. Then next page, B schedule property. Then C schedule in page 39.
There are several properties.
Yes, several properties and several purchasers.
Let's see, that's no, again, we'll go back to the plaintiff.
Please.
According to her, when the cause of action approved.
Please. In fact, not in the plain, she has made an argument that suit is also filed to suit 85 of 2010. Cause of action is page 32, para 22. The cause of action for the suit is arose on 1/6/2016 when the plaintiff approached the defendant number 1 and they inquired regarding the compromise in the earlier suit and also to give her legitimate share in the suitable property, which was refused by defendant number 1. That is the only cause of action.
So when you know that it's a joint family property, then all the members of the joint family should be the signatories to your sale deed.
No.
That you have not done. So why can't she file a suit?
No, but thing is, since we have sold the property for family necessity, and she can take the share in the sale consideration.
Her case is that she is not aware of such a sale.
No,
So probably that's a content, so let's see that.
no, there's, in fact, page
Let's read from para 7,
7, please.
7 of the plaintiff.
Please. Two properties are the ancestral property of the plaintiff and the defendant number 1 to 3. The plaintiff and defendant number 1 to 3 are the joint owners and the joint possession of the suitable properties, and no partition has been effected between the plaintiff and the defendant number 1 to 3. Defendant number 1 being the father of the plaintiff and enjoyed the ancestral property, and without the consent of the plaintiff and without there being any family necessity has sold the ancestral joint family property to defendant number 19 to 26. Defendant number 1 has neither taken the consent of the plaintiff nor taken the signature of the plaintiff on the respective seal deeds. The plaintiff being the daughter of the defendant number 1 is a co-person and has got equal share in the suitable properties. The sale made by the defendant number 1 into 1 and 2 are neither for the family necessity nor for the benefit of the estate. It is submitted to the plaintiff being the daughter of the defendant number 1. The provisions of the Hindu Succession Act 2005 is applicable to the plaintiff. Plaintiff being the co-person is entitled to the claim equal share in suitable property equal to that of his son, that is defendant number 1. It is submitted to the suitable properties bearing number so and so, were originally measuring so and so, were originally leased to Madhukanta, wife of Lakshmidas Dharwad, and Lakshmidas, son of Babudas Dharwad. The said justice way back in the year 2004 filed a suit against the members of the Belagavi family, and the suit was numbered in OS number 45/2004. Said suit was pending before the second additional senior division Hubballi, and the same is ended in the compromise between the family members of the Belagavi and then the lessee, Srimati Madhukanta, wife of Lakshmidas Dharwad, and Sri Lakshmidas Bapudas Dharwad. By virtue of the sale compromise, some of the portions of the properties were given to the Dharwads, and the properties mentioned in the A schedule were exclusively given to the Belagavi family. The defendant number 1 and his brothers were the parties to the said suit and also the compromise petition. The properties which were described in the A schedule are the ancestral property of the plaintiff and defendants. It is further submitted the properties mentioned in the A schedule A have
Why
been
it
sold
should
to
be
defendant number
rejected?
19.
Under which, why it should be rejected?
On two counts. One is suit is barred by limitation, and she has not valued the suit as per the market value. Two contentions have been made.
That we can ask them to do it. Court can always ask the plaintiff to do
that
it.
is
That
there,
can't be a ground there.
but plaintiff government does not disclose regarding the limitation. And admittedly, one more suit has filed, page 31 in where she has not questioned that decree.
If she is not questioned, she will face the consequences of that.
No, my submission is, conveniently she has questioned the sale deeds. And she has not questioned that OS 85 of 2010, page 31.
But what you have to understand is, all these things cannot be decided in an application under Order 7 to 11. You may be having a good case on merits of it,
That's right.
but the scope is very limited under Order 7.
But the averment of the plaint does not disclose not the cause of action and also regarding the limitation. The sale deed is of the year 2006, suit is filed in the year
So,
2006.
once you take the aspect of limitation, court will frame an issue and will decide it. No, if summarily in this manner, if we decide.
No, I am not saying that suit is to be dismissed in its entirety. I am seeking only rejection of plaint in respect of defendant number 19.
No, then in that case, a property has gone. Let it be decided. Please come.
The fourth aspect is also not been considered by the trial court.
That will leave it open so that let it be considered, and if there is any deficit court fee that needs to be paid, then the plaintiff will be directed to pay.
That question may kindly be directed to be considered first and then.
One more aspect, you asked its kind permission.
Yes.
One more aspect is that the Supreme Court says that plaint cannot be dismissed in part. That's also one of the.
Yes. The present revision is filed, agreed with the orders passed in I number 27, in OS number 238 of 2016 on the file of so and so, dated 25th November 2021, whereby the trial court had dismissed an application filed by defendant number 19 under Order 7, Rule 11. The first respondent herein is the plaintiff. First respondent herein, who is the plaintiff herein, has filed a suit for partition, and also she sought the declaration that the sale deed dated 27/7/2006, 26/4/2010 are not binding on her. According to the plaintiff, the suit scheduled property is a joint family property, and without her notice, and without her knowledge, and without there being any necessity, the father, that's a defendant number 1, had sold the property.
Defendant number 1, 2, 4 to 7, qualified.
The defendants have sold the property. The petitioner before this court is the defendant number 19. He had purchased the suit scheduled A property from defendant number 1, 2, 4, 5, 6, 7 and 12 to 18 in the year 2006.
36, 2016.
27/6/2006.
27,
27,
yes,
7, 2007.
27/7/2006. Now, the present application came to be filed by the defendant number 19, stating that, where is your application? IA
27, case 49.
49. Has filed the application stating that the plaintiff has no cause of action to file the suit against defendant number 19, as the plaintiff has claimed her release share in the further share of sale consideration paid by the defendant number 19 in respect to the property, that is suit schedule A property, as the plaintiff has no right to seek for setting aside the sale deed executed by defendant number 19. It is also stated that when the plaintiff had sought for setting aside the sale deed, it should have been that the sale deed is not binding on you.
Yes, prayer one is not is in the plaint. Prayer one I sought for against the relief against the defendant number 19.
It is a case of the defendant that plaintiff has sought for setting aside the sale deed. The court fee ought to have been paid under section 35(1) of the Karnataka Court Fee and Suit Valuation Act on the market value of the property. On the date of the filing of the suit, the market value of the Schedule A property is much more.
Court fee is to be paid under 35, even bracket 2, not 1. That's
Sir,
our
and it's been
contention.
under section.
It is paid under 35(1), but it ought to have been paid 35(2). That is the,
No, but the affidavit, that's what you wrote.
yes,
Therefore, since the plaintiff has sought for setting aside the sale deed,
Yes.
the court fee ought to have been paid under section 35(1).
yes.
That's what you said
Right.
in the affidavit.
Setting aside of the KL, not binding on a.
35(1) of the Karnataka Court Fees and Suits Valuation Act. On the date of filing of the suit, the market value of the Schedule A property is much more than the sale consideration. It is stated that the plaintiff ought to have paid the court fee before that it should have been, that the court fee has been paid under section 35(1) of the Karnataka so and so. But it should have been paid under section 35(2) of the Karnataka Court Fees and Suit Valuation Act. And it is also the case of the defendant that the suit is barred by limitation. The sale deed is dated 27/7/2016 and the suit is filed in the year 2016. As such, the plaint has to be rejected. The trial court had dismissed the said application filed by the defendant number 19. While dismissing the said application, the court had observed that
Page 10 of the Improved Act. 14 is the reason. Page 14.
yes, the court observed that while considering an application for rejection of plaint, only the plaint amendments have to be looked into. It's a case of the plaintiff that she asked for share in the suit scheduled properties, but defendants denied to give her share. Therefore, she filed the suit. Court observes that the cause of action has to be gathered from bundle of facts as stated in the plaint. According to defendant number 19, at the time of filing of the suit, the property is not a joint family property. The court also observes that the law of limitation is a mixed question of law and fact. And even on that ground also, the plaintiff cannot be thrown out at the threshold. Court observes that if the plaintiff undervalued the same and same has not been corrected despite of time granted by the court, further, defendant number 19 in his application submits that the plaint of the plaintiff be rejected to the extent of defendant number 16.
19.
Defendant number 19. There is no such provision. There is no provision as such for partial rejection of the plaint, and the same cannot be considered. And the court had also relied on a judgment of the apex court, and further observes that the defendant, either in the application or in his argument, not submitted that on which provision of law the suit of the plaintiff is barred. The defendant number 19 in his affidavit stated about the facts of the case as per them, as discussed by the court. At the time of considering Order 7 to 11 application, the court cannot look into the contents of the written statement and documents as per the certain law, and accordingly dismiss the same. Next para. Let counsel appearing for the petitioner defendant number 19 submits that he has purchased the property in the year 2019, in the year 2006, and the property was sold by the defendants for the joint family necessities. If at all, from the said amount, if she seeks any share, that she can settle between that can be settled between the plaintiff and the defendants, and for that purpose, the sale deed that is executed by the sale deed executed in favor of the defendant number 19 need not be set aside. It is also submitted that when she is seeking to set aside the sale deed, then she has to pay the court fees as per section
35(1).
35(2), I think you are saying.
No, they have paid it under 2, but 35(1) is required to be paid.
As per section 35,
1 is to be paid.
as per section 35(1) of the Karnataka Stamps and So Act,
Court fees.
Court Fees Act, he submits that the plaintiff is undervalued and the same was not considered by the court. And also the suit is hit by as it is beyond limitation, and even on that count also the suit cannot be entertained. When counsel submits that the court had failed to take into consideration all these relevant aspects and dismiss the application filed by the defendant and order 7 to 11 of CPC. Next para. When counsel appearing for the respondent, the plaintiff submits that the court had rightly considered the scope of an application and order 7 to 11 and rightly dismissed the application. The prayer that is sought by the defendant is, as far as the prayer in respect of defendant number 19 is concerned, that has to be rejected. He submits that in that manner, the court cannot pass such an order, and that is contrary to the settled law. The court fees and other issues can always be decided by the court, and that cannot be a ground for filing an application under order 7 to 11. He submits that the court has rightly considered that the defendant could not make out a case under which law the suit is barred. It is submitted that the court, concerning all the aspects, had rightly dismissed the petition, and no grounds are made of seeking interference with well-considered order passed by the court. Next paragraph. Having heard the counsels on either side, peruse the entire material on record. The suit is filed for partition and also a declaration that the sale deed is not binding on them. What is the court fees to be paid? That has to be, if an objection is raised by the defendant, the same has to be considered, and the court will pass an order, and basing on such order, the court fees has to be paid. If that is not paid, the consequences will follow, but that cannot be a ground to reject the plaintiff. Then coming to the argument of the learned counsel for the petitioner that the same is barred by limitation. Here in this case, it's a case of the plaintiff that she is the owner of she is a member of the joint family, and the properties are the joint family properties, and without her notice, without consulting her, the properties are sold, and there is no necessity for the joint family to sell the properties. And she has stated several factors in that regard, how the defendants have denied, the other family members have denied her right to the properties. It's a case of the defendant that they are not the joint family properties. Now, while considering an application under order 7 to 11, court cannot look at the written statement or the defense that is taken by the defendant. It is undisputed fact that the plaintiff and the defendants are the members of the joint family. When she is entitled for a share and the same was not given, she has every right to file a suit for partition, and she has filed the same. And whatever the grounds that are raised by the defendant cannot be decided under Order 7, Rule 11. And the same can be decided by the court by way of a full-fledged trial. The relief that is sought by the plaintiff is beyond the scope, or that by the defendant is beyond the scope of Order 7, Rule 11. And in the considered opinion of this court, the trial court had rightly considered the application and dismissed the same. In view of the same, this court is passing the following order. 1. This court do not find any malice in the revision petition. Next, with regard to the court fees, there shall be an issue in that regard, and court shall pass appropriate orders in accordance with law. It is open for the parties to raise their respective contentions, accordingly disposed of. Yes,
First, court may kindly be directed first to decide whether
court fees can be decided on the issue of court fees. Yes. Next.
Number 48, number 24. Mauritius Maywood.
it kindly be taken by Monday.
This is matter on 11th of November. Yes. Huh? Because on 4th, 5th, 6th and 7th, so many adjournments are
Only
there.
issue regarding jurisdiction. So
This is matter on 6th of November.
Interim order may kindly.
Interim order only granted is extended till then. Yes.
Number 49, Restitution open. Question number 1.
The respondent plaintiffs have instituted suit allowed in OS 130 part 2015, seeking a declaration.
What is this R1 deceased
They have already legal years have come on record.
have come?
Yes.
Who is appearing? Sridhar. Huh?
Question number 1.
Inform him, we'll pass over, take it in the afternoon.
Instead of Paso, some afternoon, some inconvenience.
Tomorrow?
11th.
This is matter on 11th, no representation on behalf of the respondent. What will happen is, now again I have to hear and
Yes.
again, we should give them one opportunity. Yes, no representation for the respondents.
Interim order may be extended.
Interim order only granted is extended till then.
Number 50, this is Jaya.
Malaj, I'm appearing for respondents to EC. Malaj, please submit fairly beforehand that the judgments that were relied upon by the petitioner day before yesterday, those were not in my knowledge, and I did not receive them from the client also. Accordingly, I have perused them and I am ready to proceed with the matter now.
So, according to you, does it apply to the facts of this case?
Malaj, it actually doesn't, because the extent of land in the present matter is different. Right now,
Extent. Now we are on a point whether they are entitled to the interest and solatium and other things.
Malaj, my only argument is that presently we are under revision from the execution court's order. The document which they are seeking to execute, the arbitral award of 2012, did not provide for any additional solatium or interest.
What do you say about that case? In that case also same situation.
Well, in that case, but they had challenged it under writ jurisdiction of the Honorable Court, and the court had passed orders under writ that they are to be granted additional interest and solatium in that particular matter. Herein, in these matters, he has not been, for execution of decree, there is no decree in his favor which grants him additional solatium or interest, nor is there any High Court order. Nor is there any order passed by the Honorable High Court that to this extent of land, there is to be granted solatium or interest. Accordingly, the execution court took note of this fact.
In that case, we will give them the liberty to approach the court.
Well, that may be done.
In matters of this land acquisition, I mean, the property rights, as far as the third party rights do not occur, then the limitation cannot be a ground. So we'll
Well,
ask, because when they are entitled, they are entitled. Similarly,
well,
situated people are having that relief.
well,
But
it's
the-
yes, liberty may be granted to them. We don't have any objection to that. Liberty may be granted. We'll contest the case at the respective stage.
Yes.
In this case, so far this event and solicitation.
No, while considering whether you're entitled, no, the arbitral award or whatever is the order which is executable should contain all this. The executing court will not decide the other things by going. So the executing court will not decide. The other judgment which you're relying on, in that, when it came up to the High Court, when they have questioned that award itself, and the court has passed some order. Now here in this case, that's not the point.
I'll submit my report.
Please, what you do is,
Directly I will come to the honorable principal.
let's go to that. Yes, please come to that order.
1990 judgment, NHL C1, my lord.
Page number, please refer to page number.
NHL C1, dated, page number, NHL C1, my lord.
C1 is a judgment of the Supreme Court. No. What I am asking you is, what is the order impugned? That we will see first. That's an EP.
No.
That's an EP. That's order at. Starts from 130.
That's page number 196, if I'm not wrong. Impugned order of the execution court.
Page number 120, my lord. Page number 120.
No, I think some problem with your pagination. It's not at 196.
Well, it's the compilation I'm having of the petitioner, I'm referring to that.
120, my lord.
No,
The
is it 10125?
Well, it's what is he referring to?
He is referring to the order of the court. That is at page 130.
130. Well, that's 130. I have some different order. I have the compilation of the petition only. I'm referring to that only. I have not paginated this. But it's matter number. Is it the execution court's order?
Yes. Execution petition number 302 of 2015.
Final order, my lords?
Yes.
Well, that is at a different page number in my compilation.
Yes. No, 1 minute. The petition is filed to execute the award passed by the arbitrator in arbitration case. Where is the arbitration that award? Where is that award? Arbitrator's award.
Arbitrator's award.
Annexure.
E. V. V.
Yes, ma'am. Page number 66, my lord.
66.
66, my lord. Relevant page 66, my lord.
Please read that. What is the award?
Yes, my lord. I will come to page number 65, my lord.
Yes.
I consider in view of that the petitioners are entitled for 4,186 per square meter, which is one. Since already this amount is awarded in respect of the adjoining land, 1,043 for 1 drum in the year 2002 itself. Then I come to the next parameter. Further, NHI is that they have possession of the property on 15/4/2002, my lord. This is admitted. Then I will come directly last parameter, before order, my lord. In view of the WP number 6715-17 for 2002, CAC, entitlement of 12% additional market value and 30% solicitation is not admitted, as the land acquisition act 1984 amended 60 years of 1894 is not applicable to the land acquisition proceedings after National Area Act 1956. Accordingly, claim was rejected. Even I had claimed before they admitted because
So your statutory benefits were rejected by the arbitrator.
first time I filed an application in view of the Honorable Supreme Court, my lord, dated 19/9/2019. I have filed an IA, my lord. In this, in
We'll go step by step.
Yes.
No, by way of the order of the arbitrator, all the statutory benefits which you are seeing
Yes,
were
ma'am.
rejected. Then have you assailed this order?
No, my lords.
What my member submission, madam? I have filed an application in EB 302/15 only.
No.
That was admitted. That was considered by the district court, my lord.
No, not that. How can they?
Here I with
No, execution, you are seeking execution of an award that is passed by the arbitrator. When arbitrator has not granted certain things, under which law he is entitled to
because
give?
in view of the change of law, in view of the Supreme Court judgment, I will keep that only, my lord, relevant portion only.
What they say, that
page number-
even in the EP also that can be granted.
Yes, madam.
Let's see that. Page number
Page number 120, my lord.
Page number 125.
120, my lord.
Please come to that.
Page number 120, my lord.
129 is what?
120, my lord.
Yes, the judgment of the Supreme Court.
Here, I will tell you, my lord. The affidavit I have clearly mentioned. In view of the judgment not only, I have tried to say, my lord, Supreme Court judgment. It is completed that the order of the bench is passed. The ASR are granted to get additional market share of under section 23 only.
No, only I want one clarification.
Then
Whether, no, you have filed an IA before the executing court. Is the executing court empowered to grant such an order?
But in view of that, the district court only allowed my IA. District court only allowed my this award to interest, etc.
That is set aside by the appellate court.
Yes, district court only principal to honorable. Yes, I will call read that.
Then why are you before this court if that is allowed?
Page number 139.
No, if that is allowed, why are you before this court?
Because they have rejected the execution petition, my lord. Right court. Because Honorable Justice Adi has passed an order. I will come to relevant question only. After filing this IA and filing the objection.
No, you have filed an
Page
IA.
number 145.
No, you have filed an IA in the light of the Supreme Court judgment. You are entitled for all the reliefs,
Yes, ma'am.
all the benefits. Where is the order of that?
District court, ma'am.
Uh,
The page number 145, directly I will come. Honorable Principal District Judge Judgment, madam.
140?
5, madam. The delay in disposal of the case will seriously burden exchequer of the government. JDR is liable to pay interest as well as
So,
solicium.
146, is this order questioned by them?
No, my lord,
They have not questioned
not
it.
questioned.
Then thereafter
Then I
what
will come-
happened?
I will come one by one, my lord. Here, JDR is liable to pay interest as well as solicium on the compensation amount. Then para 21 I will come directly. Here, superior officer to put to the matter and have to focus the accountability of the officers of NHA is not depositing of the legal bill payable to decree holder immediately after passing the award by the arbitrator and keeping the matter pending for the last 8 years. So the increasing burden of government to pay more interest, Allah is observant money. Then you are my lord. Here, past this honorable court, JDR shall pay interest on the compensation awarded from the date of taking possession of the property, that is from 2002, my lord. And then another second question, my lord. Decree holder shall pay stamp duty on the award.
Your solicium and all not granted.
My lord.
Solicium and all not granted even by this IA.
Here, chairman.
Where is it
Page
granted?
number 145.
No, order is, what is executable is 146.
Well, yeah, the same similar condition
Might
was
have-
taken, similar
might have-
condition was taken, since there is no arbitral award passed by the arbitrator in order portion, the Honorable Supreme Court has held in this case only that they have taken possession, they cannot urge that it is, when it is observed in the court, any part of the judgment, it has to be obeyed by the NHAI. That has been up to Supreme Court, that their appeal was dismissed, my lord.
Again, is this order, they went to Supreme Court.
Yes, my lord, regarding possession.
Not regarding
This
possession.
portion. This,
Where is the Supreme Court order?
Yes, my lord, I will come to that also. Thereafter, it was filed, this may kindly be, NHAI, my lord. I filed, so far stamp duty is concerned, that is held in our favor, my lord. Then I will
Please
come to-
clarify one thing to the court. At 120, you have referred to this application under section 151 CPC. You sought for the market value, entitled to get additional market value under section so and so, 50% of the market value from the date of taking possession of the land.
Yes, ma'am.
And you are also entitled to get solatium under section so and so, 30% on enhanced compensation amount. This is the relief. When you come to the order portion at 146, come to 146, the court simply says, you shall pay interest on the compensation.
It can observe by the body itself.
But not the body. As you know, what is executable is an order. If that order is not containing.
That's why I am submitting, my lord.
Uh,
Even such type of contention was taken in while challenging the arbitration award, they have specifically contend that in the they have not stated in the order that they are liable, they have taken position as on 2002 and 15/4/2002 only. But it was observed in the judgment portion. So that is not binding on us, they have taken similar contention. But this Honorable High Court has held that once it is observed in the judgment, it is binding on them. I will may I read?
Yes. Yes, where is that?
It is there.
Page number 1.
They have challenged that in the late petition. One five of the deputy C minor. The caption petition is filed challenging only the interest part by containing that the respondent claimants are entitled for the interest from the date of the award, that is 31/2012. They are challenging my lord. Then I will read only the result question, my lord.
So this writ is filed by you.
By NHAI, my lord.
What is this writ at page number 148? That's not your writ.
I am not line 148, my lord. 169, my lord.
169 writ.
That writ is filed by me and it was held in our case. So far, the stamp duty we are not liable.
I think some problem with the paginations. What you are referring to, what I am referring to or not.
169, my lord.
169.
Yes, ma'am. NHAI has filed the
168. 168 is the,
relevant judgment.
yes. Yes.
And I will read it. The caption civil division petition is filed challenging only the interest part by considering that the respondent's claimants are entitled for interest from the date of award, that is 31/10/2012. Then I will come to relevant question. Here, my lord.
Yes.
Para number 9. Technically, they have taken question on 15/4/2002. And further, the petitioner cannot be permitted to take up the issue of taking up position. The executive court has meticulously examined the relevant material on record and has rightly clarified the petitioner here to deposit the award which exists from the date of taking possession of the property. On examination of the order under the challenge, I do not find any material irregularities in the order passed by the executive court. So this is one. In this regard, I submit my order. In a additional catch Supreme Court judgment.
Yes.
After hearing the learned counsel for the petitioner and learned senior counsel for the respondent, we are convinced that petitioners have made out a case for interference with the institute order, especially if it is filed by the NHS dismissal.
Yes.
This is one. And so far, this one more ruling I am submitting, madam.
No.
The honorable
No, now they have taken it till the Supreme Court.
regarding this.
Then what happened?
That was dismissed and we
You
have
filed the execution.
we have filed the calculation memo, etc. The honorable trial court has held that so far as this compensation is concerned under the NHA Act, interest, etc., the remedy is somewhere else. And so far interest is concerned, they have to be satisfied. That also I am submitting to this honorable court.
No, please come to that order of the executive court. We'll read it. Yes.
Fourth portion. After a principal district judge became a high court judge, then it was transferred to fourth exceptional district judge, my lord. Then in this, the relevant portion I will give, my lord.
Page number.
Page number 24. The NHA has admitted that they have taken a position of so and so 54/2002, and the petitioners have produced a letter in support of their claim with regard to take position of the land. The respondents have admitted in their letter to accept the award amount along with the 12% from the date of implementation. Then I will come to our even though in 15/4/2002, in spite of the Supreme Court judgment, it's a 4-level submit ಮಾಡಿರ್ತಾರೆ in page number 10. The arbitration proceedings is 4-1. Then my lord, now with this question, I will not read you now because already they have admitted after Supreme Court that so the judgment passed after Supreme Court, my lord, 15/2002 is admitted, date of the case. Then my lord, I will come to here 24, my lord, page number 31, my lord. The learned counsel appealing for the review order has made reliance on the judgment of the Honorable Supreme Court in appeal number 7064/2019, stating that the Honorable Apex Court has passed section 34 of the National Highway Act. The landowners are entitled for collision as well as interest as per the provisions of the Land Acquisition Act. So in this the trial court observed in paragraph 6, page number 79. The only point indicated before us by the learned solicitor generally that in paragraph 23 of the issued judgment of the High Court, it has said that a landowner should be henceforth be entitled to solicitation and interest as initiated by the provisions of section 23 and 28 of the Land Acquisition Act 1894. In the ultimate paragraph of the issued judgment, it has been mentioned that in respect of all provisions made under the National Highway Act, solicitation and interest in terms of similar to those contained in section 23 and 28 of the Land Acquisition Act have to be clear out of Java. then accordingly it is directed that the award of solicitation and interest on solicitation will be made effective only to proceedings pending on the date of the High Court order to the as of 2008, and further the order arranged for solicitation as well as interest as envisaged by the provisions of section 23 and 28 of the Land Acquisition Act. Then para 26, my lord. Here, this court has passed an order in execution section number execution section on 22 and already I have read this honorable court, my lord. 22/2020, where this court has also stated about the payment of interest and solatium. And in the said order, it was also ordered that the decree holder shall pay liquid stamp duty on the award passed by the arbitrator within the period of 1 month from the date of the order. The decree holder shall challenge the order, said order, before the Honorable High Court of Karnataka in WP number 140591 2000 with respect of payment of stamp duty. The Honorable High Court of Karnataka in the said inspection has set aside the order dated so and so. This is one argument. In this regard, my lord, I will come to this directly. After observing this, I will come to here, my lord. Page number 23, my lord. 38. The conclusion of the order is that judgment for under reference code in 7604 section 34 of the National Highway Act is that the decree orders are entered for solicitation and the interest as envisaged in section 23 and 28 of the LA Act. The learned function of the decree orders has also submitted that the judgment of the civil appeal number 7604 up to each class during the pendency of the arbitration case. Thus, the said judgment is applicable to the present case on hand, and the judgment and decree orders are liable to pay the solicitation as well as the interest to the decree orders as per the provisions of the Land Acquisition Act. The court has passed the order on 22/10/2020 with regard to the payment of interest to the decree holder. So, my lord, the order of 22/2020 passed by this court shows that the judgment records are paid interest on the compensation awarded from the date of taking possession of the property from 2002. Even I have already read my lord, the principal case has already the judgment records are liable to pay quantum and solicitation. In this regard, I submit.
No, there is absolutely, there is.
I will submit for doing that.
Please understand. There is absolutely nothing wrong with this order passed by the executive
I'll come to
court.
that matter. In this case, my lord, the honorable court has district has overruled the judgment passed by the principal district judge. From that, only I have read ruling, my lord. Relevant page.
Mr. Counsel, let's have clarity in the facts that I want to know. Now,
Supreme Court judgment.
not the Supreme Court judgment, please understand for a minute and then we'll go to the Supreme Court judgment.
Yes, ma'am.
No, before the executing court, you do not dispute the fact that the arbitrator, please listen to the court, just then you can answer. And before the arbitrator, nothing related to interest or solution was never discussed by the arbitrator, never was granted. Only enhancement was done. Then while filing an execution petition, you filed an application under 151. In that, you have sought for solatium, interest and other things. Then the court has granted only interest of 9%, nothing else. Then that was questioned by the National Highways Authority by way of a writ petition. That was dismissed. Against that, it was carried to the Supreme Court. That was also dismissed. And the order of the executing court in your application has attained finality. But nowhere, solatium was never discussed in any of the judgments. Now you want your case to be considered in the light of a Supreme Court judgment in execution proceedings. How they can consider all that?
My humble submission in this regard, my lord. So far, solicitor and interest is concerned, the Honorable Supreme Court has held that once the judgment is passed, it cannot be it cannot be challenged by the other side because it is not challenged by the other side also in this case. Principal decision already has said they are entered from solicitor and interest, my lord.
Where did he say? He didn't say. He didn't say about solatium.
In body it has been observed, my lord.
What you should have sought is that order should have been questioned by you, or you should have sought for what has been contained here. That in execution it is not there.
And they have to file an application under section 152 of the judgment passed by the Supreme Court, my lord. May I go to that question?
Yes. Yes.
Number 198.
One.
198.
There are two numbers on each page. Which 98?
166. Earlier I have filed the question.
That is 166 of that page.
166.
Yes.
Later changed as 188.
Please.
Obviously, the other hand, such interest has already.
We are reading where at that page? Para number?
Sorry, madam. This is in respect of interest. This, I will come directly to page number 280.
280.
280. Page number 218. Word number 186. This is third paragraph. It is the last three lines on here. It is only after the judgment is both pronounced and signed that alterations or additions are not permissible. So, what are my members of the principal BJ in subject matter? The additions are not permissible except under the provisions of the section 152 or section 140 of the suit procedure code. In very exceptional cases under section 151 of the CPC. Here they are not challenged at the body, which are mentioned in the body of the judgment. It is binding.
That's for you to. That's not for them. It's for you to. What is executable is an order, not the judgment. Not the. We can't. The executing court will not read at the contents. What is the order that is passed? That is executable. That's the decree. So if the decree is not reflecting about solatium, it is for you to file an application before the court and say what has been there in the body of the order is not reflected in the decree.
Yes, I do agree, my lord. Then in this regard only, arbitration award can be granted. I will come directly arbitration award. That is, here arbitration award is B, my lord.
Yes.
Next, B, my lord. Page number 66, I will come.
Yes. Yes.
Yes, my lord. Here, my lord, order question may can be granted, my lord. The claim of the claimant is hardly allowed. NHI is directed to pay the enhanced compensation of 4,186 per meter for the land acquired with survey number 604, 6,436. Deduction compensation already paid. NHI is also directed to 59% interest awarded amount from the date of taking position. Here my lord, from the date of taking position, where it is there, it is not mentioned. Date of position is not at all mentioned in the order question. Only in body of the question, it is mentioned, in page number 65. The NHS has dedicated just they have taken question on 54. So here also they have contained.
No, that's what if things of that nature happens, it's for the party who is affected by it to seek a clarification. Because that clarity is not there, it has led to all that. Now again, before the executing court also, the same thing happened.
I do agree. What happened is similar contention. It was not mentioned in the in the order question.
No, again, please come to that order in the EP, that is page number 120. Come to 120 again. Please come to the body of the order where the judge has discussed about it. That is at page number 130. You are saying that at the bottom of it, the body of the order that is mentioned about the solatium and all. Let's look at it.
Page number 140, 145.
Please read.
Yes. The delay in disposal of this case will seriously burden every sector of the government, since JDR is liable to pay interest as well as solicitation on the compensation amount. This is one petition.
Yes, Mr. Counsel.
Sir, at the outset, I would like to submit that the compilation that is before the Honorable Court is completely different than what has been submitted to me. The impugned order of the Honorable Court, the final order in my compilation is at page number 196.
No, please look at that particular order in the EP where they have filed an IA seeking interest.
Which para is he referring to?
About 20 para. Para number 20, above para 24.
So para number 20.
It starts in the other page, that is running page 15. Page 16. The delay in disposal. It starts like that. Read that.
The delay in disposal of this case will seriously burden exchequer of the government, since JDR is liable to pay interest as well as solicitation on the compensation amount.
So, that is not reflected in the order.
My lords.
That's the only thing in the case.
Yes.
They have an order on solatium also. Your only case is no order is passed by any of the court, he is not entitled. And this is a question by you has attained finality.
My lords, now if I may invite Lordship's attention to the final order of the execution petition. Final order of the impugned order. My lords, at page para number 31, if we see of that order, my lords, since my paging is different. My lords, para number.
Yes, para number.
Just a minute. My lords, para number 32. My lords, I'll read from the beginning, para number 32. Admittedly, the said award, so and so dated 31/10/2012, is not challenged by the decree holder and the judgment debtors. Hence, the award in so and so Belgaum dated 31/12 has reached its finality, and execution petition is filed to execute the award passed in the award dated 2012. In view of the award passed dated, the decree holder claimants are entitled for a compensation of 4186 per square meter for the paid for the land acquired in survey number 604 measuring 6430 square meters, and also interest at the rate of 9% on the rate of taking possession. As per the award, there is no order as to pay solatium and also interest as envisaged under provisions 23 and 28.
That's the crux of the issue.
That's my point.
That's beyond the scope of the powers of the executing court.
That's all, Master.
What I'm saying is, in the earlier execution petition, in that IA which has attained finality, in the discussion there is a mention about solatium, which is not reflected in the order.
My lords.
In the similarly situated people, by way of an order passed in the writ petition, they also got an order. This thing we clarify. Why should we deny them the right?
My lords, my issue is, if at all it is contested and a specific order to that effect is passed, my lords, here we are revising the IA order, which is not even impugned before the Honorable Court. What is impugned is the final order.
So why should there be a litigation like that? You acquired their land. You are the beneficiary. Then why not? When the similarly situated people have had the benefit of the order of the court, and that too, it's merely a clerical mistake according to the court. When there is a distinction.
My only anxiety is that, is this the appropriate jurisdiction within which this can be done? That is my only anxiety, because there are judgments of the Supreme Court.
The courts have to look at the substantial justice to the parties also.
My lords, that is there.
So, in cases of this nature, where you take possession of the property in the year 2002, and in the light of the settled law, you deny them their right.
My lords, for an instant, I am not denying them anything. Whatever is awarded by the explicit orders of the Honorable Court and the authority, that we have awarded already. The issue right now is what is not directed and what is not awarded till now. If this Honorable Court in its wisdom deems it fit and orders payment of solatium, that will be in a different context. But if you look at their memo of calculation, what are they claiming? They are not just claiming solatium, my lords.
It is not an executing court. We will not go into the calculation.
That's all.
We will only settle what is right, what is the law, whether it is as per the law or not. According to him, he is entitled for solatium. According to him, there is no order from any court.
That's all.
To pay the solatium.
Yes.
In the opinion of this court, there is an order which has attained finality, which consists of solatium and their entitlement.
My lords.
That we clarify. Let them come up before the executing court about what is the calculation, what is that. Let them come up, and you will also have an opportunity to file your memo of calculation. According
My lords, that may be done. That may be done.
Our own High Court has observed in one judgment.
Take that.
Because that's only three para, relevant para only I repeat, madam.
Which para?
Yes, madam, only relevant para.
Para number 11.
Otherwise, not para number is clear, sir.
The Honorable Apex Court in Dharwad case. Is that the one? You passed on AR online 2023 Karnataka 1896.
Yes, madam, in the respect of true property, when there is a change of law, it has to be considered in spite of wasting the time to the clients.
Let's see, there is a.
I underline that, madam.
It is well settled that it is a duty of the court, whether it is trying original proceedings or hearing an appeal, to take note of the change of the law affecting pending actions and to give effect to the same. So we are exercising original or appellate jurisdiction by deciding your CRP.
And on the case of circumstance, it has to be considered clearly after that. This is after the
It's altogether in a different, we are on a point, whether the executing court, now we will be telling the executing court to go beyond the decree. If unless and until the decree is drawn properly.
change of law and
Where did he say so? Please read that. Please read it, please read that. You don't have the copy? That's the only copy he has.
Here I have got a copy, but I have marked in that office copy.
Give him that and take that copy.
Nim copy. Submission. Yes, my lord, case number 581.
581.
Now, it is well settled that, paragraph 48, my lord. Second paragraph, it is well settled that it is the duty of the court, whether it is the trying original proceedings or hearing an appeal, to take notice of the change in the law, effective pending action, and to give effect to the change. This is one, my lord. And then I will come directly 582 page number. In this portion, I will read directly. The Honorable Apex Court held that the court has always power to revise the preliminary decree or pass another preliminary decree.
Where are you reading?
Middle portion, 582 after 8 to 9.
Yes, I've seen.
8 lines. In 582 page number. Middle, the Honorable Apex Court. The Honorable Apex Court held that court has always power to to revise the preliminary decree or pass another preliminary decree if the situation in the change in circumstances so deemed. So, in view of the Supreme Court, my humble submission, the trial court ought to have taken into consideration.
Because court cannot take that into consideration, that was never argued before the court.
I have argued submitted rulings all.
Yes.
Then D parameter, in para 20 D parameter, last D. As partition 2 is required to be decided in stages, the same can be regarded as fully and completely decided only when the final decree is passed. If the law governing the party is amended before conclusion of final decree proceeding, the party benefited by such amendment can make a request to the court to take cognizance of the amendment and give effect to the same. It is well settled that the court of first instance as well as the appellate court are entitled to take into consideration any change in the law. The common law court by deciding the question whether any person is entitled to any legal character cannot ignore fundamental change in law. We are partially now, my lord, here also the Supreme Court ruling came because they came to effect during the pendency of the execution section. That's why I am reading this portion, my lord. Yes. So far,
No, that we will not go into. Let the trial court decide. We'll ask it. Both of you go before the trial court.
According to them only, only one that portion I submit. That is page number 175.
Yes.
Page number 175. They have submitted the memo, my lord, while depositing the amount. That as per the order of the Honorable Court, today I have submitted the demand draft getting so and so, for so and so, along with the calculation memo, my lord. I read that calculation memo, my lord, page number 174. So, all looking at 89,995. As per according to their own calculation memo, they have submitted this, they have deposited this amount, my lord. According to their own calculation, how the trial court has come to a conclusion that they have paid excess amount, my lord, without observing it, without assigning any proper reasons, my lord. They only, it is not my calculation memo, my lord. It is their own calculation memo.
Yes. We'll pass orders in at 2:30 because it will take a lot of time.
Well, it's one submission if I may make.
Yes.
In my additional statement of objection filed on record, I have referred to one judgment of the Supreme Court. Well, I'll just read the relevant para for the convenience of the Honorable Court. Well, in Sethi versus R.P. Kapoor, additional statement of objection, my lords, page number 9, para number O. I have reproduced the point of judgment. I will provide the judgment also in the lunchtime. Meanwhile.
Yes,
in Sethi versus R.P. Kapoor, AR 1972, the Supreme Court has held that the jurisdiction of the High Court under Section 115 is a limited one. The section is not directed against conclusions of law or fact in which the question of jurisdiction is not involved. Section 115 empowers the High Court to satisfy itself on three matters. A, that the order of the subordinate court is within its jurisdiction. B, that the case is one in which the court ought to exercise jurisdiction, and C, that the exercising jurisdiction, the court has not acted illegally, that is, in breach of some provision of law or with material irregularity by committing some error of procedure in the course of trial, which is material in that it may have affected the ultimate decision. And if the High Court is satisfied on these three matters, it has no power to interfere because it differs from the conclusions of the subordinate court on question of fact or law. An erroneous decision on a question of law reached by the subordinate court, which has no relation to question of jurisdiction of that court, cannot be corrected by the High Court under Section 115. That is all my submission, my lords. I'll provide the copy also to the Honorable Bench.
Yes.
Grateful, ma'am.
page number 198, relevant panel. They have not calculated the interest on capitalization method in view of the Honorable Supreme Court. And further, I have submitted one more ruling, non-prosecution court ruling. They are also clearly held, my lord, that the
Now, you are now only, you have impugned that order passed by the executing court, saying that the executing court cannot go beyond the award that is passed, and the award is silent about the solatium. Now, that part of it we will clarify. That in the IA that is filed by you, the court has clarified that you are entitled for solatium, though that doesn't form part of the order. You are entitled for it. Whatever is the calculation that you can make, that you can do the executing court, and the executing court shall decide it.
on the land holders are entitled for without soliciting interest.
That's what.
In view of
That.
they have given consent in another case, my lord, but not submitted.
Yes. Any other in respect of the other matter, the court has already given. But the difficulty is, just like that, because it is given in some other matter that you want the same relief, that is not the law. Yes.
The legal advisor of the National Highway Authority has given consent, will give the interest, etc.
Place that whatever it is, in the afternoon will pass, 2:30 will pass the order. Yes, next.
Grateful, Manoj.
Pass over. Yes, 54. How much is the maintenance granted?
8,000.
8,000 to the wife.
Wife, no issues.
Huh?
No issues.
No issues.
No issues.
Yes, 8,000 to the wife.
And
What is the income of the husband?
Income the not shown, 8 to 10,000 minus. The document is not on record.
Please come to that order. Order of the trial court.
Order 34 minus. Page number 32, tab number 34.
Page number 32.
32, tab number 34.
It's in Kannada.
Yes, Kannada minus. Register of minor.
List this matter after vacation. After vacation. If you want to file a.
There is arrears of 3,55,000 euros.
I am ready to pay.
How much?
3,55,000 euros. I have filed the statement of objection.
My lord.
Till today they are not paid any amount.
They are paying 2,92,000 in execution issue. Similarly, 22/24. Interim order has been passed, interim maintenance that is 4,000. I have totally paid 55,000 to 60,000 deposition before the guide. And I am ready to pay the 1 lakh rupees before this.
What is the order of the court? Where is the interim order?
Interim
Interim order speaks about the arrears also.
Arrears is 5,000, last page, my lords. That is, by deduction is page number 34, my lords. From 11/5/2022, this honorable court has issued last operating part of the order, my lords. 11/5/2022. So the trial court has given interim maintenance, my lord.
Not the trial court. What is the interim order passed by this court? Any interim order?
No.
Then you have your own right to file the execution petition. Yes. Yes, next.
Which is a very petition. Petitioner has filed this petition seeking transfer from Hubli to Ballari.
Hubli to?
Ballari.
What is the distance?
219 kilometers.
290. Which year is this, the petition MC?
In the year 2020.
20?
24.
That's good.
Stay has already been granted.
The present petition is filed seeking to transfer MC number 08 of 2024, pending on the file of the first additional principal family court Hubli to principal family court Ballari. The facts of the case are: the marriage of the parties is organized on 11/6/2020 at Ballari. In view of the differences between the parties, the respondent husband has filed MC number 8 of 2024 on the file of the Principal Family Court at Hubli, seeking a decree of divorce. And the wife had also filed MC number 57 of 2024 before the Principal Family Court Ballari for a decree of restitution of conjugal rights. And the court at Ballari has already issued notice to the respondent in MC number and also placed him ex parte on 16/4/2024. It is submitted by the council that the petitioner is residing at Ballari. She has lost her father and she has no income of her own, and she is depending upon her mother and brother for her livelihood and for day-to-day expenses. And the mother and brother have no sufficient income to maintain the petitioner. And for running the family itself, they are facing a lot of difficulties. And further, it is stated that the health of the petitioner is also not good, and it's difficult for her to travel on every date of hearing for 213 kilometers to attend the court proceedings. Next para. Though notice is served on the respondent, no wakalat is filed on his behalf. Considering the submission of the learned counsel and the fact that she is residing at Ballari along with the mother and the brother, and the distance between the two places is about 213 kilometers, and considering the convenience of the wife and also the MC for restitution conjugal rights is pending at Ballari, this court is passing the following order. The MC pending on the file of the MC number 08 of 2024 pending on the file of the First Additional Principal Family Court Judge Hubli is withdrawn and transferred to the Principal Family Court Ballari. Accordingly, allowed. Yes, next. Pass out, let's do that one. Yes.
Arising out of execution proceedings, petition is by judgment debtor. Application under section 47 has been dismissed. Challenging that present petition. Brief facts of the case are discovered.
What's the suit for?
Suit is one for specific performance of contract. In the suit, we were placed ex parte. We did not contest it. And thereafter, we filed.
When was the suit declared?
Suit was decreed 1/2/2021. Agreement is of
1/2/2021.
21. On 12/7/2021, we filed a civil miscellaneous 27 of 2021. And it was dismissed for non-prosecution on 30/9/2022.
Oh, second round.
First round.
No. First round, you're already set ex parte. Then you file an application to set aside the ex parte order. Then again, it is dismissed for default.
Yes, they are.
No, first time you didn't appear before the court.
Yes, no.
That's first step. Second step is this. Then
next, I filed recently. I filed restoration of this miscellaneous also.
That's pending consideration.
That is pending for
Then, in the meantime, you will file the section 47 petition.
In the meanwhile, execution was filed. I filed section 47 application. In this case, facts of the case are this. This is a Devasthan Inam land. Petition property. This is Devasthan Inam land. And in the year 1983, my grandfather filed form number 1 before the land tribunal, and it is pending for consideration. In view of enactment of Certain Income Abolition Act, as on that day, land vests with the government. I am not the owner of the property. Now,
you are not the owner of the property. Then, what is the prejudice to you? Then they will. Court will execute the sale, right? And they will take care of it.
State is the owner.
You are representing whom?
Not I'm the judgment debtor. My grandfather filed form
That's
number 1.
what I'm saying. You have no interest in the property. Property is the government's property. Why you are fighting for it?
Well, as on
No.
execution
Your
is
court
filed.
will execute the sale deed.
I'm not a owner of the property. On my behalf, court is going to execute the sale deed, my lords. On my behalf, court is going to.
Then why did you enter into an agreement?
Sorry?
Why did you enter into an agreement when you are not the owner of the property?
I
You can't blow hot and cold at the same time. You will enter into an agreement. You will take money. How much is the money taken by you?
4,64,000.
4,64,000. Then suddenly you realize that you are not the owner of the property and you file a petition under 47. You file a restoration petition that gets dismissed for non-prosecution. Yes, come to the order passed by the court.
Now it's page number 11
Yes.
from the facts one.
Yes.
Page 12. The judgment.
Let's read from para number 2.
Para number 2.
Yes.
In support of the application, judgment number 3 filed affidavit alleging that decree passed in respect of the suit property bearing RS number 403/24A/1 measuring 107 acres is Devasthan Inam land, and the judgment debtor's grandfather and father of the judgment number 3 was holder in possession and enjoyment of the said land. The judgment debtor submits that their grandfather filed form number 1 before the land tribunal for grant of occupancy rights in his favor, and the same is numbered as KLR so and so on.
Even these proceedings have not attained finality
No.
in 1974.
Still pending for that. And during the pendency of the same, he was died, and they have come on record as his legal heirs and representatives. The same is pending for consideration. The judgment debtor submits that the alleged agreement of sale in respect of the land to an extent of 6 acres 20 guntas and 11 guntas of 107 acres of land is barred under the law, as the said property is not at all granted to the holder.
Have you filed that constatement? Have you filed that
No,
constatement?
no. I have not at all appeared on it.
Then in that miscellaneous petition, have you stated about all these things? To set aside the ex parte order?
Not at all granted to the holder of the land on the alleged dated of agreement, and the proceedings in respect of 107 acre of land which is Inam land is still pending before the land tribunal, and thus they cannot execute the agreement of sale to the decree holder. Thus the decree holder cannot claim specific performance of contract, and the decree is not executable in nature. Since the suit land is still Raitawa land, and the said property cannot be alienated through the process of the court for execution of the sale decree. Therefore, the decree passed in OS number 597/19 is not executable in nature, and the sale agreement is in violation of Karnataka Inam Abolition Act and Land Reforms Act. The judgment debtor submits that.
Yes, please read.
The judgment debtor submits that the decree holder, having knowledge of the same by suppressing the said fact, filed a false frivolous suit and got the decree for specific performance of contract. Thus, for all these reasons, the decree passed in OS number 597/19 is not executable in nature, and the same is barred under law. Therefore, prays for dismissal of the petition by allowing the application. Per contra, decree holder filed detailed objections to this application, contending that judgment debtors have already filed civil miscellaneous 27/21 in respect of the judgment and decree passed in OS number 597/19, and the same is dismissed on 30/9/2022. Further, the judgment debtors have not challenged the judgment and decree passed in OS number 597/19 as on this day, and there is any such appeal is pending, and the judgment and decree passed in OS number 597/19 is become final. Under such circumstances of the case, the question of executability of the decree at this stage of the case does not arise for consideration. The learned counsel for the decree holder submits that once the decree is passed by the court, the executing court cannot go beyond the decree, whether it is executable or not, unless it is set aside or modified by the Honorable Appellant Court.
Please come to para number 10.
10. On plain reading of section 47, it reads that all questions in respect of execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree. Here, the judgment debtors have alleged that decree holder, under the fraud and misrepresentation, got obtained the decree as the suit property was Inam land, and the judgment debtors are holders of the land suit property, and they are in possession and enjoyment of the property. The judgment debtor alleged that the alleged land is inam land and they have no any right to execute the agreement of sale in favor of the decree holder / plaintiff, and the matter is still pending before the tribunal. But to substantiate the same, the judgment debtors have not filed any document to show that the suit property is inam land and they have no better title to execute the alleged agreement of sale in favor of the decree holder / plaintiff. Further, the judgment debtors allege that decree holder by playing fraud against them got obtained the decree. To substantiate the same, the judgment debtors have not produced any cogent or reliable evidence on record. It is specific contention that contention of the judgment debtors that they have no any title to transfer the suit property in favor of the decree holder as the suit property is inam land. As discussed above, judgment debtors have not produced any reliable evidence or document to show that.
Yes, I've seen. Yes.
Please, Manoj, along with my present petition, I have produced form number 1, not at in page 21, which was 5. This will not substantiate my claim that it is an inam land, and in view of enactment of Certain Inam Abolition Act, land vest with the government.
You did not answer one question. Why did you execute the agreement of sale when you are not the owner of the property?
Execution is disputed.
How the payment is made?
But it is a registered agreement of sale.
Registered agreement.
No, registered agreement of sale and payment is made how?
But it is not mentioned in the agreement of sale, not regarding the payment.
Plaint is not before us.
Plaint is not produced.
A judgment I have produced, wherein agreement of sale is extracted. Entire agreement of sale is extracted.
Yes, we'll pass orders in the afternoon. Call this case first at 2:30. We'll complete the dictation. Signatures.
Basic for tomorrow. I got at 2:30 minutes. There is a parted matter through VC matter.
No, just it's only I heard you. Only dictation.
I need to.
You want to argue?
Yes, that is
tomorrow.
Tomorrow.
Put this tomorrow. Respondent counsel. He said that he'll circulate that. This way I take it.
Malaj, the court is not audible. Malaj, I am unable to hear the court. There's absolutely no voice. Ma'am, I'm unable to hear anything. There's absolutely no voice.
whom
No, how is it relevant?
the relevant is in the event if the petition is allowed or dismissed. If the claim of 15 lakhs is not substantiated, if I directly come in the evidence along with all those documents, then in the absence of
Husband has sought for divorce.
please,
You have not filed any, there is no counterclaim from you.
counterclaim is regarding
What is your counterclaim?
I have not filed.
No, you have not filed any counterclaim.
Okay. Well, however,
No, ultimately, the court will decide about whether he is entitled for divorce or not.
please.
So how are these facts relevant for consideration of that application?
Even in the event the petition has gone against me, I am entitled for at least for the return of the marriage expenses which I have incurred for up to 15 lakhs. I have stated
But that is nobody's case that you want that money back.
she has stated this. She has in her
You didn't seek for it. You didn't seek for it. That will not be adjudicated. What is not sought?
Again, I have to make another petition for seeking.
No, you have not sought for it even till now.
I have taken.
You just want to state the facts. That's it.
I have explained it, from where,
Which year is your counter or objections?
my counter is filed, on 22, on 12th January 22.
12th January 22. Oh.
On 23, I filed this application.
So, court was right.
My submission is I cannot
No, first of all, let us see your IA. Why is it relevant? Isn't it delaying and dragging on tactics?
No.
Let's see your IA. Why is it relevant? After 1 year, how can you come up with that? Let's see the application.
The application, the proposed amendment, which I have stated, I have explained, it in the affidavit. Tab number 2.
What is the stage of the case?
No, it is still, in the evidence stage.
No, it's still trial has commenced.
Trial commenced, now.
By the time you file the application.
Please.
Yes.
At the time of
No, let us see, let us understand from the affidavit why you want to state all those facts, place of facts on record.
Please.
Yes. Please draw the attention of the court to that particular paragraph.
I'm sorry, it is posted for respondent evidence. I'm sorry. In paragraph number 2 of the affidavit, page number 33.
Yes.
Last 5 lines. I am contesting the case by filing verified contact petition. I submit that the petitioner evidence has.
Which page is it?
Page number 33.
30?
33. Annexure D. Page number 33. Paragraph number 2. From paragraph number 2 from bottom fifth line. I submit that the petition evidence has been completed enough. The case is posted for respondent evidence. While preparing for evidence, I came to know that certain important material information has not been brought in my verified counter. The said material facts are very important for the proper adjudication of the case. Such material facts of information regard the taking of the.
So simply saying that they are material. How material it is not stated.
But I cannot substantiate in the absence of these.
No, that's what it's a suit. It's a case for divorce.
Please.
So how is it relevant?
Yes, the divorce. I am entitled for the return of the amount which I have spent for the marriage. In the absence of these the foundation facts.
At least in the petition and order 6 rule 17, you are supposed to say why you are not stated so in the earlier petition.
Please.
Why are you doing it? You can't cover up your latches by way of this petition. And what is the requirement of it at this point of time? Nothing has been stated in your petition. Please come to the impugned order.
But impugned order, the trial court stated at page number 42, para number 11.
Please read.
This being the provisions of law as invoked by the petitioner, and this court is of the firm view that the real controversy between the parties hereto is as follows.
Please read from para 8.
At the outset,
it is necessary to discuss in respect of the proposed averments. The proposed averments reveal the persons who have approached the goldsmith from whom the jewelry items were prepared at the relevant time, that is, at the time of marriage. The proposed averments do also narrate that same name and address of the goldsmith and the quantum of amount paid to him at the relevant time. It further says that the grandfather of the respondent by name Gulana was working as gangman in railway department and he got retired in the year 2005 by obtaining pension benefits to the tune of ₹3 lakhs, and it was said Gulana, the grandfather of the respondent, who gave his pension benefits of ₹3 lakhs to his son, enabling him to perform the marriage ceremony of the parties hereto. That the father of the respondent and uncle of the respondent were in the habit of investing certain amount per month in the chit fund, and that the said chit fund business was doing by a person called Ramanjani, and that part of the expenses, that is cash amount, was also raised at the relevant time out of the said chit fund transaction. That the proposed amendment do narrate that how a total sum of ₹15 lakhs was generated and the manner in which and the purpose for which it was utilized at the relevant time. The above being the proposed averments, it is necessary for this court to look into the major relief as sought for in the petition. Undisputedly, this petition preferred by petitioner husband as against the respondent by seeking the relief of...
Whatever the queries of the court, the same were raised by the court at para 30.
Please.
Yes.
Please. Lord, at the time of first hearing, this honorable court is of the opinion while granting the unity order. Lord is of the opinion that the point which has been missed without by the trial court is in the event the divorce is granted, she would be entitled for permanent alimony or for recovery of the marriage expenses if she substantiates that with proper evidence and pleadings. In the absence of these pleadings,
if you want all that, you don't have to ask for it. You don't have to ask for it. Court will on its own, it will decide that. No, I'm asking. You have to ask for it, isn't it?
That's true.
You have not asked for it.
Lord, in my counter, I have stated so that I have...
No, you have just narrated the facts.
Please.
No, basing on the pleadings of the parties, issues will be framed. Basing on the issues, order will be passed.
Please.
No, here the court has rightly observed that what is to be decided in this case is whether the wife is suffering from any of the diseases, like how, and whether he is entitled for divorce or not.
Yes.
And you never said, I want that and this. Under which provision the court will decide?
Lord, regarding my evidence to substantiate my claim that we have expended this much of, when we have stated in our counter that this is the amount which we have incurred.
Court actually wants to know from you how it will be decided. If it is decided, definitely we'll look into that. Please tell the court, there will be, unless and until an issue is framed with that regard or something is decided by the court.
If this amendment is allowed.
Not this amendment now.
No,
trial has commenced. Already the issues are framed.
If my lord kindly appreciate this, if this amendment is allowed, then an additional issue will be framed regarding on the pleadings that regarding incurring of all these things.
No, if you have incurred the amount, that itself is not a ground to frame an issue for that. If you have a claim or if there is something to be decided, then an issue will be framed. Know that marriage expenses are not of the issues in question. Then it will be of no use.
Otherwise, I may not be in a position to substantiate my
arguments. Court is ready to help you, but tell the court how it is. No, the query of the court is very simple. Now, if you are entitled, there is such a plea, such a issue, and because you have missed out all this, now you want to, by way of an amendment, you want to place on everything on record. Yes, that's a point. But where and how the court is going into that aspect?
Tomorrow,
yes.
Some research.
Yes, definitely. Definitely, will pass an order. Yes. Whether is it working?
Working. There is an interim order.
Interim order early grant is extended till tomorrow. Yes, Mr. Counsel. What's his name? Is he there online?
I'm audible.
Yes. what? Yes. In that case, file an application under 151 CPC. Believes that the DHR is entitled to get additional market value under section 23(1)(a) and 12% of the market value from the date of taking possession of the land, and the decree holders are also entitled to get solatium under section 23(2) of the Act and 30% of the enhanced compensation amount. And further, DHRs are also entitled to get interest at 9% per annum on the enhanced market value for the period of first 1 year from the date of taking possession of the acquired land, that is on 15/4/2002, and for subsequent year at 15% per annum on such enhanced amount till the date of depositing the entire compensation amount. By order dated 22nd December 2020, the court had passed an order wherein the operative portion of the order reads as, within inverted commas, JDR shall pay interest on the compensation awarded from the date of taking possession of the property, that is from the year 2002. Decree holder shall pay requisite stamp duty on the award passed by the arbitrator within a period of 1 month from the date of this order. Agreed by this order, the two writ petitions are filed. One is by you, one is by them. You have questioned the stamp duty.
They are not specific.
No, you have questioned the stamp duty.
No.
The decree holder has filed the appeal, filed a writ petition, that is writ petition number 10059 of 2021, questioning the order as far as paying the requisite stamp duty is concerned. And a coordinate bench of this court, by order dated 28 February 2022, had dismissed your writ petition. Where is that order? One minute. The court, this court, the coordinate bench of this court, and set aside the order as far as acting the decree holder pay the stamp duty on the award passed by the arbitrator under Section 3(5) of the National Highways Act within a period of 1 month from the date of order. And further, it is observed that the award is directed. I think you can mute your audio, some disturbance from your side. The award is directed to be acted upon and enforced without the requirement of making payment of any stamp duty. The National Highways Authority had preferred a CRP before this court, that is CRP number 1000015 of 2021, dated 1st of 2021, and the same came to be rejected by order dated 1st April 2021, wherein it is observed that there is a finding of fact rendered by the arbitrator that the possession of the land was taken on 15/4/2002. The present proceedings are arising out of execution proceedings, and thereby the petitioner cannot be permitted to rake up the issue of taking of possession. The executing court has meticulously examined the relevant material on record and has rightly directed the present petition herein to deposit the award amount with interest from the date of taking possession of the property. On examination of the order and a challenge, the court do not find any material irregularities in the order passed by the executing court, and accordingly, the petition was dismissed. Then the National Highways Authority had carried this matter to the Honorable Apex Court by filing SLP civil number 11264 of 2021, and the same came to be dismissed on 25/11/2021, and that the order passed by the executing court where the petitioner was where it is ordered that the petitioner is entitled for interest as a time penalty. Thereafter, the decree holder had filed execution case number 302 of 2015, seeking execution wherein different contentions are taken by the stance of the according to the decree holder. The National Highways Authority, it is the case of the decree holder that at the time of the passing the order in civil appeal number 7064 of 2019, the arbitration case is pending. The principle laid down in the civil appeal number 7064 of 2019 is applicable to the case on hand. The National Highway Authority, the judgment debtor are liable to pay the solatium and interest as envisaged under the provisions of section 23 and 28 of the Land Acquisition Act. It is a case of the National Highways Authority, that is the judgment debtor, before the executing court, that in the arbitration, in the award that is passed, there is no mention about the interest, the solatium, and other components are not included. And even as per the IA filed by them, which is ordered on 22/12/2020, is only to pay the interest at the rate of 9% per annum from the date of taking the possession of the land. As the decree holder has not challenged the award dated 31/10/2022, and they have already paid the amount, and the present execution petition filed by them is not maintainable. The court has considered the rival contentions of both the parties and the earlier litigation that went on between the parties, and the court observes that as per the award, there is no order as to pay solatium and also interest as envisaged under the provisions of section 23 and 28 of the Land Acquisition Act. And the court has also recorded the submission of the judgment debtor that the executing court cannot go beyond the award, and the scope of the executing court is very limited. The executing court has to execute the award and cannot pass an independent order, and the court cannot go beyond the award. If the decree holder is seeking solatium and interest on that, its remedy is available somewhere else and not before before the executing court. So as far as the award of the arbitrator, and as per the orders passed in the execution on the IVA filed by the decree holder, the court has come to the conclusion that that amount has been satisfied by the Highways Authority. The judgment debtor has fully satisfied the award dated 31/10/2012. As such, the execution petition filed by the decree holder is closed as fully satisfied. Agreed thereby, the decree holder is before this court. Learned counsel appearing for the decree holder submits that the Honorable Apex Court in Civil Appeal number 7064 of 2019 declared that the provisions of the Land Acquisition Act relating to solatium and interest contained in section 23(1)(a) and 2 and interest payable in terms of section 28 proviso will apply to acquisitions made under the National Highways Act. It is also stated that in respect of the adjoining lands, where is that order? The writ petition order he has given the other day. You said one order with regard to 3,000 square yards. Division bench order. The other day has passed on.
It's in writ petition number 104809, I think. That he filed.
Yes.
Day before yesterday.
Yes, sir. Take that. Single judge order is Justice Krishna Kumar's order. Krishna Dikshit. No, you must have gone to the single judge first. No, this is, I think, the order which, that is Justice, single judge is Hemant Chandan order, and the other one is Justice Krishna Dikshit's order, not this order. In respect of an extent of 3,790 square meters, which is adjacent to the very same land. When the arbitrator has failed to grant solatium, they have approached this court by filing the writ petition. Then the same was disposed of, directing the National Highways Authority to pay solatium at the rate of 30% as per the Land Acquisition Act. And also, the court had directed that the said exercise shall be concluded within a period of 4 months from the date of receipt of the certified copy of the order. Agreed thereby, the National Highways Authority had filed writ appeal number 100209 of 2024, and the same came to be dismissed by order dated 9th September 2024. In that order, the court has observed that that the writ petition is filed seeking a direction to pay solatium at 30%, additional market value at 12%, and interest at 9%, and 15% as per the provisions of the Act for the land in survey number 604, measuring 3790 square meters, as per the decision of the Honorable Supreme Court in Tarsam Singh case. And the court, considering the judgment of the apex court in the said case, the court observed that the contention of the National Highways Authority that the law laid down by the apex court in Golden Iron and Steel Forging versus Union of India, reported in 2008 SEC online PNH 498, applies to the case. The court held that the said contention has no merit, as the application in AC number 3 of 2006 filed under section 34 of the Arbitration and Conciliation Act 1996 was pending as on the date, and the same came to be disposed of on 17/4/2008. Hence, the cutoff date claimed by the NHA would not help them in any way. And the court has observed that the law laid down by the apex court in Tarsam Singh's case refers supra that the land users are entitled to solatium and interest as per the provisions of the Act 1894, even though the acquisition is made under the provisions of the National Highways Act, and accordingly rejected the application. Next para. Learned counsel appearing for the petitioner decree holder submits that in the execution petition, in EP number, execution petition number 302 of 2015, dated 22nd December 2020, though the order discloses that the JDR shall pay interest on the compensation awarded from the date of taking possession of the property, that is from the year 2002. But in the judgment, there is a discussion, and the court has observed that the delay in disposal of the case will seriously burden the exchequer of the government, since JDR is liable to pay interest as well as solatium on the compensation amount. Land counsel submits that the same is not reflected in the order. He submits that when the similarly situated persons have had the benefit on these technicalities, his claim cannot be rejected. He had relied on another judgment. Court officer, so that he has given some other order of Justice Satyan Bakri. He has relied on another order passed by a coordinate bench of this court, and in Sushilamma, since died by LRs and others versus K. Sitaramaya and others, arising out of regular second appeal number 2586 of 2010, dated 2/11/2023, reported in 2024, reported in AR Online 2023, Karnataka 1896. Then counsel has drawn the attention of the court to that it's a duty of the court, whether it is trying original proceedings or hearing an appeal, to take notice of the change in law affecting pending actions and to give effect to the same. If the law states that after its commencement, no suit shall be disposed of, or no decree shall be passed, or no court shall exercise powers or jurisdiction, the Act applies even to the pending proceedings and has to be taken judicial notice by the courts. At paragraph number 7, it is observed that the Honorable Apex Court held that court has always power to revise the preliminary decree or pass another preliminary decree if the situation in the changed circumstances so demand. A suit for partition would continue after passing of preliminary decree, and the proceedings of the suit gets extinguished only after passing of the final decree. He submits that the courts at the first instance as well as the appellate courts are entitled to take into consideration any change in the law. The common law courts, by deciding the question whether any person is entitled to any legal character, cannot ignore pendent change in law. If after passing the preliminary decree in a partition suit, but before passing the final decree, the rights of the parties are altered by statutory amendment, it's the duty of the court to decide the matter and pass final decree, keeping in view the change scenario. Basing on this judgment, learned counsel submits that just because the initial arbitration award do not contain is entitled for solatium, that cannot be a ground for the court to disentitle the petitioner from having the relief as it is given to the similarly situated persons. He submits that the court ought to have considered all this and ought to have granted the relief as he is entitled and as prayed for by him before the executing court. Next para. Learned counsel appearing for the National Highways Authority, the judgment letter submits that the petitioner is seeking the relief which is beyond the jurisdiction of the executing court. Learned counsel submits that what is executable is a decree, and the decree do not contain anything with regard to the solatium and the funds. It is submitted that the petitioner, the executive court has rightly held that the court cannot travel beyond the judgment, but beyond the decree, and has rightly held that already the decree is satisfied and all the amounts are made by the decree or by the judgment letter. He submits that the persons who are parties before the writ petition, in the writ petition as well as in the writ appeal, they cannot be equated with that of this petitioner. Yes, they have availed the remedies available to them. When the arbitral award do not include the solatium, they file the petition, and then thereafter the National Highways Authority has filed a writ appeal which came to be dismissed. He submits that even if they are similarly situated in a CRP, the filed before this court, the petitioner cannot have any relief as it was granted in the writ petition. He submits that the scope of inquiry before this court in a revision petition is very limited. He has relied on, give him a copy, that's for him. He had relied on the judgment of the Apex Court in Shri M.L. Sethi versus Shri R.P. Kapoor, reported in 1972 to SCC 427. Which para?
Well, it's para number 12 onwards. Well, it's the inverted comma section, the last part under the para 12. From there on till the next page, till the end of next page.
Is it the dicta of the majority of the House of Lords? Is it?
Well, it's continuing that. Yes, the in inverted commas, the question then is, did the judges of the lower courts in this case from that onwards?
From here, extract from here till para 13. Relying on this judgment, the judgment of the apex court, and counsel submits that the prayer that is sought by the petition for the executing court and executing court is beyond the scope of the court conferred on the executing court, and this court also cannot pass an order exercising the jurisdiction under section 115 CPC. Next, having heard the counsels this side, peruse the procedural on the
Well, if I may interject for one, there's only one observation may please be taken from para 15 of the judgment of 2020. The 2020 judgment passed by the EP court, execution court, wherein the solatium has been discussed in para number 20. Of the same judgment, para 15 may also be referred to. The learned execution court has stated in the middle of the para 15 malats. The executing court, in the middle malats, the executing court cannot award compensation beyond the terms of the award if decree holder was not happy. That para and
already recorded in the same place argument is.
That's all malats.
Yes. Having got the counsels on either side, peruse the material on record. In this case, an extent of 6,430 square meters was acquired by a position was taken by the National Highways Authority in the year 2002. In respect of the other extent of land where the solatium is granted, in that case also an extent of 3,790 square meters was taken possession by the National Highways Authority. In this case, as rightly pointed out by the land counsel for the respondent, the arbitral award is silent about the solatium and interest and other parts. Even the arbitral award is silent, though in the award it is stated that the land is acquired on so and so. Even in the operative portion of the order, that is also not mentioned by the arbitrator. Initially, when in the execution, when he has filed an IA under 151 CRPC, that is entitled for solatium interest. At that point, the court had interfered and passed an order that is entitled for interest. And though the operative portion do not contain that they are entitled for solatium and interest on that, but in the judgment there is a discussion on that. As far as that aspect is concerned, the National Highways Authority has carried that matter to this court and further to the Honorable Apex Court, and both the courts have held against the National Highways Authority. In this particular facts and circumstances of the case, the first and foremost submission that the executive court cannot go beyond the award or the decree. As far as this case is concerned, already an order is passed, which is affirmed by the Honorable Apex Court. The counsel appearing to the respondent do not dispute the fact that, as per the judgment of the Honorable Apex Court, they are entitled for, what are the components? They are entitled for at 30% as like in land acquisition proceedings, that solatium at 30%, additional market value at 12%, and interest at 9.9%, as per the provisions of the Act. Like it is contention of the Council for the District that at an appropriate time and by way of an appropriate proceeding, as they have not come before this court, they are not entitled to any fees from the court. And he has also argued before the court about the powers of this court or the while exercised by this court while considering a revision petition. According to the learned counsel, this court cannot interfere or pass an order, and what is not contained in the order cannot be they can't supplement it or supplanted by this court. Admittedly, the respondent Highways Authority of India has acquired the extent in the year 2002 till for a long period. The one after the other, several petitions were filed, and the matters have been pending before the courts. The only thing that the decree holder ought to have done is, when in the discussion there is when he sought for interest on solatium, and when that particular aspect was not found in the order, operative portion of the order, the petitioner ought to have, ought to have filed an appropriate petition before the court and sought for a clarification. That he has not chosen to, that he has not done. Now the National Highways Authority is taking advantage of the same and trying to say that just because that order do not contain, they're not entitled to, the decree holder is not entitled, and they are not liable to pay the money. The petitioner's right to property by initiating the proceedings under the Highways Authority Act has been taken away by the respondents, and it's a duty of the respondent to pay the landowner which he is legally entitled. In this case, both the position in respect of this land and the other land, which is part of the order passed by in WP number, in writ appeal number 1000209 of 2024, is one and the same land, and that order of the division bench has attained the division bench has affirmed the order of the learned single judge and held that they are entitled for solution, basing on technicalities and on the fact that such a clarification was not sought by these decree holder at an appropriate point of time, cannot be a ground for this court to disentitle the petitioner from having the solatium and interest on solatium which he is entitled. The learned counsel submits that the only submission of the learned counsel for the respondent is with regard to the jurisdiction of this court, and the second aspect is that as they have not questioned the award passed by the arbitrator, and where the do not contain solatium and other clauses is not entitled, this court has to look at the substantial interest to the parties, and even if the matter is remanded to the court, they cannot get over the legal hurdles and unnecessarily for the acquisition and the position that is taken in 2002, even after 20 years, or still the decree holder is not able to have the fruits of the same. In that view of the matter, this court deems it appropriate to to set aside the order passed in execution case number so-and-so, dated so-and-so, and direct the trial court to consider the execution petition filed by the decree holder in terms of the order passed by this court in writ petition number 104809 of 2023, which is affirmed by the division bench of this court in writ appeal number 100209 of 2024. Both the parties are at liberty to file their respective calculation memos before the court, and the court shall decide the same within a period of 3 months from the date of receipt of the copy of the order. Yes, next. Yes. You've seen there are so many objections. Morning objections, the same thing, no? No, the application is filed. After that, what should be done? Filed a memo that so and so died. After that, what should happen?
I have filed memo, my lord. The memo for reporting death of respond number 5, my lord. There is a
You should file an application to bring the LRs on record. Have you filed that? Huh? Or they're already on record. Give that memo. Where is that? You just say, respondent number 19 reported to be dead, and she do not have any surviving legal heirs. Same may kindly be taken on record. Then what about the other one? Respondent number 16, 17 and 22 have not claimed the notice issued by this court, and petition is not claiming any relief against us. Such notice too may be held sufficient. Has died as per the postal endorsement so and so. 18 are already on record. Therefore, they are treated as legal heirs of so and so. Please come. About 3 memos are filed stating that respondent number 18 died as per the postal endorsement, and already the legal heirs of respondent number 18 are on record, that is respondent number 19 and 24. Hence, they may be treated as legal heirs of the deceased respondent number 18. Another memo is filed stating that they are not claiming any order, any relief against 16, 17 and 22, and notice to the respondents may be dispensed with. Accordingly, the notice to at the risk of the petitioner, notice to respondents 16, 17 and 22 is dispensed with. Another memo is filed stating that the 9th respondent died in the revision died, but there are no surviving legal heirs. Considering these 2 memos, the petitioner, the petitioner shall file the amendment, carry out the amendment to the cost item accordingly order. Okay, the memos are taken on file. Yes. It is submitted that for the process is already paid. This is matter after service of notice to the other respondents. Yes.
Number 50.
This is wife's petition.
Yes.
Wife's petition.
Oh.
The husband has instructed a divorce petition before Kushal at Kodagu. The wife has filed a maintenance petition at Bhagalpur and seeking a transfer from Kushal Somwarpet to Bhagalpur. The
No,
distance
no,
is
no. This is the wife's petition. Wife filed?
wife filed maintenance petition before Bhagalpur.
Husband has.
has filed a divorce petition before Somwarpet.
What is the distance?
500 and odd.
500 and odd kilometers. What is, which year is this MC?
Sorry,
MC is which year?
23 months.
When did you file this petition?
This is 31st January 24.
What is the stage?
Both petitions are at the MC petition, Lord, it is about the cross examination of plaintiff.
At least a trial has commenced.
Yes, ma'am.
When did you file the petition before this court?
31st January, Lord, but interim order was not granted by this.
Then what is to be done now?
But he has not paid a single penny so far. And
See, now the trial has commenced. Now at this point of time, why should we transfer it? Tell your client that it cannot be transferred.
the only issue is not she has one child of 6
No,
years.
that's true. That's true. You should have, first thing is you should have come at another earliest point of time. Or at least when you come in Jan, there should have been a stay in this. Now it is at the cross examination. Already the court has spent a lot of time. Now we can't transfer it. Or else at best what we can say is on every date of hearing he should pay some amount to her.
That can be done.
How much?
She has requires 2 days for the traveling itself, my lord, and
So
staying
traveling
accommodation that has to do. And in fact, my lord, he is financially very sound person. He has deserted her in the 2021. Since then till today, he has not paid a single penny. And on the record, my lord, that my lord, he is living with some other lady. These are the allegations, my lord. And she is still today, she is ready for the judgment.
Notice is served on him.
It is served.
Please come. The present petition is filed seeking transfer of MC number 27 of 2023, pending on the file of the Senior Civil Judge and JMSC, Somwarpet, and transfer the same to Principal Judge, Family Court, Bhagalpur. The petition before this court is the wife. Wife had filed a petition before the Family Court and Bhagalpur and criminal miscellaneous number 56 of 2023 seeking maintenance for herself and for her son. And the husband, who is the respondent herein, had filed MC number 27 of 2023 before the Senior Civil Judge and JMFC Somwarpet, Kodagu for divorce. It is submitted to the learned counsel that the distance between both the places is 500 kilometers and odd. And it's difficult for her to travel all the way to Somwarpet from Bhagalpur to contest the matter. It is submitted that the husband is not taking care of the wife and the son. And in the interest of justice and the convenience to the wife, the matter may be transferred to Bhagalpur, to the Family Court at Bhagalpur. Though notice is served on the respondent, there is no representation on behalf of the respondent. Having heard the counsel for the petitioner, peruse the material on record. On a query from the court, what is the stage of the proceedings in the MC? Let counsel submits that it is coming up for the cross-examination of the wife.
Husband.
Cross-examination of the respondent husband.
One more submission. He is the resident of Bhagalpur itself. He is just working.
He is working.
He's working at Somarpet, na? He's the resident, a permanent resident of.
He's working he's in Contentions, you're right. He's a resident of Padalkot, but working in that place. So generally, whenever a transfer petitions are filed, this court, the courts will take into consideration the convenience of the wife. At the same time, the petitions have to be moved at an appropriate point of time. In this case, already the trial has commenced. Once the trial has commenced and the considerable time has already been spent by the court on this, at this point of time, transferring the case from one court to the other is nothing but is waste of the wasting of the judicial time. Considering the fact that the wife has to travel from so and so to so and so, this court deems it appropriate to grant deems it appropriate to direct the husband to pay some amount to the wife so that she'll be in a position to travel and defend the case. And also, accordingly, this court is passing the following order. 1. The husband shall pay an amount of rupees 3,000 on every date of hearing. The date of hearing to the wife. 2. The court shall dispose of the matter as expeditiously as possible, but not later than 6 months.
Instead of that, madam, if it is transferred, both matter can be clubbed and common recording evidence may be recorded.
The shall be disposed of within a period of 6 months. This court do not find any reasons to interfere. Do not find any reasons to transfer the matter. Accordingly, this court wrong. Give that list. Yes, next.
Number 56, Assumption, CSF, authorization, number 56.
No representation for dismissal tomorrow. Yes, next.
Second time possible was 17. Serial number 17.
Office objections have been complied with.
Doctor, the office objections are complied with the petitioner and we file the certified copy of the order. Yes.
Lord, petitioner is a tenant in a charge proceeding for the rent court. Lord, petitioner also holds a sale agreement executed by landlord and he has filed a suit for specific performance. It is also pending. Lord, now landlord files an application under section 45 of the Karnataka Rent Act, seeking to stop the proceedings and hand over the vacant possession because tenant has not paid the arrears of rent. Lord, the tenant files a statement saying that he is willing to deposit the rent subject to under protest, but he is not willing to take. So the application filed by the landlord is dismissed by the rent court. Lord, under section 46, landlord prefers a revision against that dismissal of the application. Well, the application came to be dismissed. But however, a direction was issued in the operative portion, revision is dismissed, but tenant shall pay arrears of rent within 10 days, failing which possession shall be handed over. My Lord, Annexure G, Annexure G, page number
66.
Yes, page 38, starts from page 38, Annexure G. And the operative portion, my Lord, is in page 43. I'll request Lordship to go to page 43. The revision petition is dismissed. The respondent is directed to pay the entire arrears of rent till date within 10 days from the dispute. Now, what happened is, since
now
it is dismissed,
you're ready to pay.
Yes, I'm ready to pay. It's not, what happened is, counsel thought it is dismissed and kept quiet. After this lapse of 10 days, the counsel for the tenant realized that even though the revision petition is dismissed, direction is given and the time frame is fixed. So he filed an application before rent court saying that kindly permit me to deposit. By the time 7 days had elapsed. So the rent court said, no, revision court has fixed the time frame of 10 days. You are 7 days late.
So now you know when you are going to pay?
I'm going to pay tomorrow itself. If Lordship directs, I will pay before the rent court only. May permitted.
Agreed with order dated
Annexure G and Annexure M are questioned.
13th. It's a consequent.
And I moved for extension of time before revision court.
Which court?
The same revision court.
So which order is in a one writ petition? You can't question two orders.
No, the same case. Same case, two orders.
No, that is true. But orders are independent. How can there be an order, one court and the other court, both in one writ petition?
No. The court of the order of the revision court only. Revision court dismissed the writ petition on 13
Please
May.
understand. Either this court will, either the impugned order should be at page 38 or the other order. Which is the impugned order? Not both. Both can't be by way of one CRP.
No. Both are passed by the same court. After dismissal, I moved the same court seeking to enlarge time under section 148 CPC. That is also dismissed. And Annexure M. I have challenged both. Annexure M, madam.
You cannot be agreed by this order. If you are agreed, you are agreed by this order.
Basically, Annexure G only.
Agreed with orders passed and what is the date of order?
13/9.
16/10.
Annexure M
2024.
is 16/10.
16/10/2024. Whereby the court had dismissed the application filed by the tenant seeking extension of time to deposit the arrears of rent. The tenant is before this court. The counsel the petitioner submits that he is ready to deposit the amount by tomorrow. That is, tomorrow is 25th October. He is ready to deposit the amounts by 25th October. The petitioner shall deposit the amount by 25th October. If the amount is deposited,
Before rent court.
before the rent court, there shall not be. What is the earlier order? That
And handing over possession.
that there shall not be any interference with the position of the tenant. Issue notice to the respondent.
It is uploaded, the order is uploaded today so that I can take the printout.
Upload the order.
Yes.
Yes, next. Yes, issue notice to the respondent. Yes.
This is a transfer petition filed by the wife relationship seeking transfer of PMC 46 of 24 from a family court Davangere to family court Haveri. Wherein the petition filed by the wife is pending relationship.
Haveri, what petition wife filed?
Maintenance petition.
Maintenance petition.
Maintenance petition.
Which year is this MC?
24 years.
What is the stage of MC?
Okay, for objection also.
Objections. Other side is already served.
Served and
Unrepresented. The present petition is filed seeking transfer of MC number 46 of 2024 pending on the file of the family court Davangere to the family court at Haveri. The facts of the case are that the marriage of the petitioner wife and the respondent is organized on 9/12/2021. And you have the differences between the parties. The respondent husband had filed MC number 46 of 2024 and the family court Davangere seeking divorce. The wife had filed criminal miscellaneous number 49 of 2024 before the family court Haveri under section 125 CRPC seeking maintenance of an amount of rupees 20,000 per month. Land council appearing for the, what is the distance?
75 kilometers.
Land council appearing for the petitioner submits that the distance between Davangere and Haveri is 75 kilometers. That the wife had no source of income and it's difficult for her to travel on each date of hearing to Haveri. Hence, Haveri or Davangere?
From Haveri to Davangere.
From Haveri to Davangere. It's 74 kilometers. 74 kilometers. The seeks for and file this petition seeking transfer of the same to Davangere, Haveri. This court has issued notice on 19/7/2024. Stay of all further proceedings is also granted by this court. Notice is served on the respondent, but no wakalat is filed on behalf of the respondents. Considering the submission of the counsel, the petitioner, and the convenience of the wife, and considering the fact that the distance is 74 kilometers, and it would be difficult for her to travel, this court is passing the following order. The MC number so and so, file pending on the file of so and so is withdrawn and transferred to so and so. Accordingly, allowed. Yes, next.
Seal number 6.
59.
Once challenging the order of maintenance.
How much is granted?
9,000, 5,000 to the wife and 4,000 to the daughter.
What is your income?
Well, my income is I am working as a contract labor, that is driver under corporation, and drawing a salary of it is 12,000 rupees per month, madam. So that is a meager salary I am drawing, madam. And
Sir,
then
is it an ex parte order?
no, it is a contested matter.
Court considered that your income is 12,000.
No, may I take your option to the order which is passed and the reasons which are assigned. At page number 25, that is 15 of the judgment. It has only relied on the evidence of that is the respondents and some.
No, it is a criminal miscellaneous of 2021. Have you filed your statement of health and liability?
Yes.
As per that,
the matter also.
please come to that particular paragraph where it has reference
Page
to
number
your
25
salary.
of my petition, madam.
Uh,
Last 4 lines, 5 lines from the bottom.
mm.
But the petitioner has not produced any document to show that the respondent is getting monthly income of 40,000 per month. And it is just improper to award maintenance of 5,000 per month to the petitioner.
Land counsel for the petitioner submits that the income of the petitioner is 12,000 per month and court had granted maintenance of an amount of rupees 4,000, 5,000 to the wife and 4,000 to the child, that is 9,000. He submits that the court had failed to consider the statement of assets and liabilities filed by the petitioner. Considering the same, there shall be stay of all further proceedings on the condition that the petitioner shall deposit an amount of rupees 5,000, that's 2,500 to the wife and 2,500 to the son, by 5th of every succeeding month. What about arrears?
Arrear will deposit within 6 weeks.
At the same, the arrears at 5,000.
Yes.
The arrears at 5,000 shall be deposited within a period of 6 weeks from the date of receipt of the copy of the order. On such deposit, the wife is at liberty to withdraw the money. Either the amount is not paid by 5th of every succeeding month, or the arrears are not deposited within 6 weeks. The stay granted by this court stand vacated without further reference to the court. Yes, next. For the right court, so that it will be easy for them to. Yes, next.
For respondent, madam.
No representation for the petitioner. Counsel for the respondent is present. Yes.
This case is regarding transfer petition from Dharwad High Court to Vijaypur Dharwad District Court to Vijaypur District Court.
What is the distance?
Distance is 150 kilometers.
Yes.
The petitioner, the wife, she is a government employee, madam. and she is capable to qualify and appear before the court.
She is a government employee, she has to go to office also.
And wherever the manager ceremony is at the Dharwad manor. As per,
No,
place of-
you admit that
Yes.
she's working in that place. She's a government employee.
Okay.
Yes, please. I believe the petition is transfer. MC number 246 of 2024. On the file of the President in Family Court Dharwad, Principal is Family Court Vijaypur. The husband has filed the MC 246 of 2024 seeking divorce. It is the case of the wife that the distance between both the places. You said how much?
150 kilometers.
150 kilometers. And the wife is working as a government employee. It's very difficult for her to travel all the days of your experiment. Counsel and query to the respondents of this the wife right means and as such, there is no necessity to transfer the case from Dharwad to Vijaypur. Having got the consensus of the sentence of material in the court, the wife is working as a government employee in Vijaypur, and the president is filed in Dharwad. Considering the convenience of the wife, this court is inappropriate to pass following order. The petition is allowed by withdrawing the petition from so and so, and transfer the same to so and so. Accordingly allowed. Yes, next. Yes. Yesterday's matter.
Yes, my lord.
What did you say?
Yesterday was kindly peruse page number 21 of order sheet, my lord.
21,
my lords, of order sheet. Both parties present, respondent submit. She has filed transfer petition before the Honorable High Court. Praise time, call on for production of petition copy, my lords. Tomorrow, ladies, my lord. And moreover, my lord, she has to change 3 buses, my lords. To
The present petition is filed seeking transfer of MC number 36 of 2023, pending on the file of the Senior Civil Judge JMFC. What is that? Hagari Bomanahalli. Bomanahalli, na? Hagari Bomanahalli to
Halyan minutes. To Halyan minutes.
Halyan Hadagal, something. Look at it. So and so. It is submitted that the wife is facing a lot of difficulties to travel to the said place. Considering the submissions, they shall bestow a fall further proceedings in CC number so and so, in MC number so and so. The registry is directed to issue a budget notice to the respondents. Yes. This next one. Yes.
The wife is seeking the transfer of divorce petition filed by the husband, my lord, from Goka to Hubli.
Distance.
Wife is seeking transfer.
Distance.
Distance 120 kilometers, Lord.
MC is of which year?
This year.
Say, the petition is filed seeking transfer of so and so from so and so. Land council submits that the distance is
120 kilometers.
120 kilometers. Considering the same, they shall bestow a fall further proceedings in so and so. Issue a budget notice to the respondent. Yes, next. What is this mediation report that not settled?
It is not settled. Just I came to know that the main MC petition came to be dismissed by the dismissal.
Look at the online case status, you will be knowing. It shows dismissed. When is it dismissed?
From 19/9/2019.
19/9/2000?
19/9/2024.
19/9/2024. You want to verify? It's there online.
If it is dismissed, then it is.
Yes, like counsel for the petition submitted the main MC itself is dismissed on 19/9/2024 and something there. Servers for consideration is the petition according to dismissed as instructions. Is next. No representation for dismissal on 6th of November.
You want this already?
Yes.
My lord, here, marriage between petitioner and respondent has solemnized in the year.
What is this petition about?
My lord, I filed the divorce petition, my lord,
Hmm.
and the respondent wife filed the application under section 24 for the maintenance, my lord.
How much is granted?
5,000.
What is your income?
My lord, here she is in the marriage date is on 36.
No, what's your income first? Income.
Income, my lord, 40,000, my lord.
Why can't you pay 5,000 to the wife?
My lord, here she deserted me, my lord.
So,
My lord, she having a illegal relationship.
that all will be decided in the due course, not at this point of time.
My lord, even the dates of the events it clearly shows that, my lord, there is a.
What dates?
My lord, marriage is solemnized on 36/2020, my lord,
Hmm.
and she gave birth to the child on 29/3/2021, my lord.
No, she might have her own reasons for that. She might say that the child is your child.
But my lord, after marriage she went to the.
It's there. 9 months gap is there.
8 months, my lord, but only 15 days we give the petition.
All these things cannot be decided in a petition under section 24. Please come.
My lord, but even she redundantly.
No, that's what, in this stage, court cannot go into all those issues now.
But my lord, now they have filed the recovery proceeding.
They will file when they it's a petition of 2023, no stay agreement.
My lord, one cannot take benefit of his own wrong, my lord.
Who will decide that there is something wrong with her? It has to be decided by way of a full-fledged trial. What is the purport of section 24? Yes, please come. The present petition is filed. Agreed with the order dated agreed with the orders passed in I number 1 in MC number 41 of 2021 dated 4th July 2022. You filed the MC seeking divorce. The petition herein has filed MC number 41 of 2021 seeking divorce. In that, the wife had filed I number 1 under section 24 of the Hindu Marriage Act seeking maintenance of an amount of rupees 20,000 per month. The trial court by order impugned, the family court by order impugned had granted maintenance of an amount of rupees 5,000 per month. The court, while granting the maintenance, has observed that the husband has admitted that he is getting an amount of rupees 40,000 salary per month. When both the parties are deciding separately, the husband has not paid any maintenance to the wife. The husband had made allegations of illicit relationship with other person and also placed certain documents. The court observes that the same shall be considered during the course of trial, and at this stage the court cannot go into the details, and it's a matter to be dealt after the evidence and the said allegation and other substantial questions to be decided at the time of trial. In view of the admission of relationship by the husband, he is bound to maintain his wife and children, that is the wife and the children. And at this stage, the petitioner, as having a sufficient means of income to provide interim maintenance, and the wife being a helpless lady and not able to maintain herself, court had granted maintenance of an amount of rupees 5,000 per month. Land counsel appearing for the husband submits that when the respondent wife is living in adultery, and he submits that the date of marriage and the birth of the child also demonstrates and also supports the case of the husband a person and a person living in adultery, she cannot claim maintenance, and the court had failed to take into consideration this particular ground raised by the husband and granted maintenance. The maintenance, having heard the learned counsel for the petitioner, there is entire material on record. The petitioner is making several allegations, and basing on that, he has filed the MC also seeking divorce. It is a specific case that the wife is living in adultery. The trial court had rightly observed that all those issues cannot be decided at this stage, and the same can be considered after a full-fledged trial. The said observation of the court below cannot be called in question. Further, admittedly, husband's income is 40,000, and the amount that is granted with the court is only an amount of rupees 5,000. The purport of Section 24 of the Hindu Marriage Act is to take care of the needs of the wife who is living out of the matrimonial home, and to take care of the person's her right to life and her right to life. Considering all these aspects, in the considered opinion of this court, the trial court had rightly considered and passed orders, and there are no grounds to interfere. Accordingly dismissed for everything, no? That accordingly the following order, whether said or not, you formulate that. Yes.
Number 66. Petitioner
Petitioner challenge election meeting. The trial court has granted 10,000 rupees maintenance. My lord, the petitioner filed a petition seeking the relief of divorce and alternatively the relief of restitution of conjugal rights.
What is that?
Alternate relief has also been claimed.
No, first relief is restitution, alternative is divorce. You ask it the other way around.
Yes, it has been done. These are the facts, I am narrating the facts. And the wife appears and she files an application under Section 24, claiming maintenance for herself. The trial court has now.
How much was claimed?
She has claimed 20,000 rupees for herself. The trial court has granted 5,000 to her and 5,000 to the daughter. Then there is no claim which has been made by her.
Which is not
because
as per it.
I have produced the application, my lord. It is filed under Section 24, claiming maintenance for only herself. And my respectful contention is, when there is no specific prayer which has been made in a civil suit, or because it is of a civil nature, so no relief can be granted when there is no claim which has been made.
What is your income?
Lord, I am doing coconut selling business, my lord. And
As per the record, what is your evidence?
As per the record, I have suffered loss.
No. As per the trial court's order.
There is no discussion as to regarding my income, my lord. She claims that I have an income of.
How much you have paid and you are paying?
My lord, in order to see that there is compliance of this order, I have paid regularly, my lord.
As of now, there is an interim order in this?
No, my lord. There is no interim order.
And you have been paying 5,000?
I have been paying.
Shall I record that?
Yes.
The learned counsel for the petitioner submits that, though there is no application by the wife seeking maintenance to the daughters, to the child. Court had granted 5,000 to the child and 5,000 to the wife. He submits that he is a coconut vendor. And he has no sufficient means. All these aspects are not considered. Learned counsel submits that he is right from the date of order. He has been paying the money at 5,000.
No, in fact, entire amount has been paid.
He has been paying the entire amount. Considering all, then you are capable of paying the amount.
Because there should not be any violation of the order.
There shall be stay of all for the proceeding pursuant to the order dated so and so, and pursuant to the order dated so and so in IN number, in OS number so and so, on the condition that the petition shall continue to deposit an amount of rupees 5,000. Issue, the petition is permitted to take for handsomers on the counsel appearing with the respondent before the trial court and shall file a memo to the defect by 14th of November. List this matter on 19th. Yes, next.
Number 67,
Petitioner.
Yes.
Husband's petition. Interim maintenance 5,000 to wife and 2,500 to daughter. My lord, kindly come to page 42. This is the only reason, para 15. Or they realize that I am a manager in the liquor shop and I have an agriculture land. Para 15 in page 42.
In page?
42. Please. It has also come on record. The respondent is working in a liquor shop as a manager and he has having agricultural land at Swami. On this, my lord, trial court has granted my lord 5,000 and 2,500.
You have filed a statement of assets and liabilities.
No, my lord. I have filed objection to my lord saying that I have no source of income. But both the parties are not filed. Will be interim order granted by this honorable court.
What's your income according to you?
My lord, only agriculture land about my lord.
Something should be there. You are living.
No, I am living. My age old parents are there.
That's what.
Yes.
So there must be some income.
Yes,
What is
yes,
that
yes.
income?
No, it is my bonding duty to look after my wife and.
No. What is the income? So that we'll understand what is to be done.
Yes, ma'am. I shall file my lord.
Get instructions. What is the income?
Yes.
Any of the respondent is not appearing.
Yes.
This is matter on 8th of November.
Please.
Yes, next. No representation for dismissal tomorrow.
Grant of interim maintenance of rupees 7,500. Already, divorce has taken place. And according to wife is not entitled for maintenance.
Divorce? This is filed under 125 CRPC.
125.
Permanent alimony is granted.
7,500 interim maintenance has been granted.
Why she is not entitled?
No, I am husband. So already divorce has taken place. And my lord, sir, I have made an annexure, kindly see annexure E. And my lord, before that, my lord, I have filed restitution of conjugal rights. Even before that court, my lord, she has appeared. And not
According to you, she has deserted you. That's why she is not entitled.
Please.
Where is that order?
My lord, sir, annexure E.
Page number?
33, my lord.
This is filed under filed for divorce.
Please.
Where do you get that finding that she is not interested to? Take that. Take that.
She appeared before the trial court and also not chosen to file written statement.
What is this? It is dismissed.
Dismissed. But at that time also I am ready to.
No, from what the court has to understand that she has willfully, there should be, if there is a finding saying that she has deserted you, then it's altogether different
No, there
case.
is no evidence at all. It is the finding of the court, trial court.
That's what I'm saying. Unless and until there is a
But
finding by
already
any
after
competent
taking
court.
of divorce, I remarried. So, sir,
125 CRPC, what it says, divorce wife is not entitled.
but willfully deserted.
That's what I'm
Yes,
saying.
yes.
Where is that willfully? Where is that observation that you have to show to the court?
Yes, sir. The very conduct of the.
All that we cannot. There should be show the finding.
May I read the finding of the trial court? Sir? Only on the
It's only dismissed.
Dismissed, but what is the conclusion, sir?
Please read. Please read.
Please. No evidence. That is the finding. And she has
You
also
filed the restitution petition.
Please.
Your petition is dismissed.
Please.
From that, you want to say that the wife is.
What I am submitting was, if she has appeared before the trial court, she has filed wakala, and she didn't choose to file written
Give it to him. Give it to him. Where did the court say they passed any observations?
Kindly say there are reasons. Petitioner to get decree shall establish that the respondent without reasonable excuse withdrawn from his society in the event of decree of conjugal right is granted, and in the event the respondent wife failed to resume the marital life, her properties would expose for attachment as held under order 2132 of CPC. Failure to obey decree of conjugal rights.
These are all discussions. This is all discussion, not that come to the reasons and that part, nothing. In fact, the court said you are not able to establish. That's why it is dismissed. So now we cannot say that she has deserted you voluntarily.
My lords, who prevented to join her to leave here?
When she comes, we will ask.
Till then, my lords.
Now we are on the point, what is your income and what is that is
My lords,
granted.
I have to take care of
That's why we'll
my
understand
disabled
that.
father.
So,
So he is suffering from paralysis.
who this person?
My father is suffering from paralysis attack, and mother, and brother, widow, and children liabilities on me. So totally I have to maintain 5 to and second wife.
You have a child out of this wedlock?
No, my lords.
Or how much the court has granted?
7,500.
So pay half of it.
Please.
The counsel submits that the wife has willfully deserted him and she is not entitled for maintenance. And this aspect was not considered by the court. Considering the submission, they shall stay of all further proceedings on the condition that the petitioner shall deposit 3,500 by 5th of every succeeding month and shall deposit the arrears at rupees 3,500 by 3,500 within 8 weeks from the date of receipt of the copy of the order. Either of the same default order. Sanction notice. Notice of the registry's ratification notice to respondents. Yes, next.
Ex parte order has been carried, my lord. By filing I number 3 and 4 before complete.
What happened to this 2016 MC? This must have been disposed of by this time.
Disposed of, my lord.
Disposed of? When?
I have no instructions about that, my lord.
Look at it, you can find it online also. Looking at the number and MC, it must have been disposed of 2016. Which court is this?
Gadag, my lord. Family court.
Gadag means it is disposed of, I know. All till 2019, all the cases are disposed of.
Find out.
Find out tomorrow. Yes, tomorrow. At the request of third counsel, petition tomorrow. Yes.
This is relating to the cinema Inox.
Yes.
And the Deputy Commissioner, without inquiry, without giving any opportunity of hearing, just suspended the license. And before that, they had seized the property, and they came to know without Mahajar, they had seized, and they allowed us to open it. Then after one day, they passed an impute order. And being agreed by the same, we challenged it before the Divisional Commissioner. By seeking permission, earlier we filed a writ petition before this Honorable Court, and this Honorable Court was pleased to grant the stay, allowing me to approach the appellate authority. But somehow some impediments were there because the appellate authority and the person who had passed an order was the same. So again, we got extended by this Honorable Court. And now the point is for consideration is it was up to year 2020, the license. It has expired. And we had challenged it in the year 2017.
You have challenged?
17. So, 2018. And the licensing authority, thereafter we approached as usual for renewal. Because the period had expired, the suspension order also has no meaning. Because the suspension order has to
pertaining to that particular
period. What has happened is, thereafter we issued a notice complying for renewal. Then they issued an endorsement.
Take that.
Saying that because this matter is pending before this Honorable Court, we cannot renew. However, because on the basis of the state granted by this Honorable Court, the state will continue. So therefore, under these circumstances,
no, you consider independently. No, this has become infructuous.
Well, kindly appreciate. Well, NF has submitted that no inquiry was conducted.
Will not go into the merits of the matter. Will not go into the merits of the matter at all. Now, this particular order whatsoever is passed for the license that is granted for a particular years.
Please.
Now suspended, whatever it is, it's worked out for him or not. Now it has become infructuous, literally. Now they have made an application. Now without going into all this,
They have not filed any application for condonation of delay before the authority.
No,
And also.
you decided.
And also, yes, ma'am, that was decided before the deputy commissioner. And deputy commissioner almost challenged before the division commissioner. Division commissioner has heard that the deputy commissioner is whole good and correct. They have not at all furnished the.
But what the court is saying is, not on the legality or otherwise of this order. Court is not going into this. We will dismiss this writ petition.
Please.
With an observation that this order not come, whatever the impugned order that is passed by you should not come in their way, and whatever the application that is filed by them, decide it independently.
No, it was found that they are selling the eatables and drinking water for higher price. And
that period
that
is
was-
done.
That was
It is
decided-
over.
That was decided before the deputy commissioner.
That I understand. It is for a particular period between 19 and 20.
Please.
Which year is that?
That was 15 to 20 years. They are like-
15 to 20.
Yes,
No, they are going to make a fresh application. If you feel that they are not entitled, tell them that.
No, their license was ended in 2016 itself.
But they have run, when you of the intermodals are passed by this court, they have been running it.
That was
No, they
not-
when is the application filed by you? This is on
Yes, 20 to 25.
5/7/2021.
Yes.
That's between?
Early, they accept that we have complied all the requisite compliance what has to be made for subsequent period. My learned brother is
1
submitting
minute.
relating.
Now, any order that is passed, it is not coming in your way. That you have to understand. They made a representation. You gave an endorsement. Because the writ petition is pending before this court, we will not consider your application. Now, this is already that license is expired long back. What is the, so the fresh application is pending before you.
Yes.
If he comply with all the norms, give him permission
Yes.
or don't give him.
That is not challenged before this court. That is not challenged before this court.
What is not challenged?
They have challenged the order passed by the division commissioner and the deputy commissioner.
My
That is not
submission-
challenged before this court. That is not
My
challenged.
submission to lordship is during pendency.
What should be challenged?
If that is for-
What should be challenged? Please tell the court, what should be challenged?
If they have made that representation.
This court is not passing any order, why are you not understanding? I'm just saying, their application is pending before you. Because this writ petition is pending before this court, you are not considering this, that's the endorsement. I'm saying, this is 2021, this is already over, consider his application, that's pending.
Then let us see their prayer in this situation.
Please come.
Their prayer is that to quash the annexure A, which is the order passed by the division
The
commissioner.
present writ petition is filed to quash the order dated 22/5/2017, issued by respondent number 3 by setting aside the order passed by respondent number 2 in appeal number 01 of 2017 to 18 dated 28/6/2018, and consequently allow the application made by the petitioner for renewal of the license to exhibit cinematograph films dated 5/2/2016. In this writ petition, an interim order is granted by this court on 18/7/2018 for a period of 4 weeks. And that interim order continued till now. Learned counsel for the petitioner submits that the license that was suspended by the respondents is between 2015 to 2020. The license that is granted for a period from 2015 to 2020 that was suspended. Thereafter, in the year 2021, they made an application. As per the endorsement given, as a petition is pending before this court, they are not considering his application. By virtue of the interim orders passed by this court, in spite, though the license is suspended, that is for the year 15 to 20, still the petitioner has continued to operate the cinema theatre, cinema theatre, considering the fact that a fresh application is filed and application is filed. This court deems it appropriate to direct the respondents to consider the application filed by the petitioner in accordance with law.
For renewal.
For renewal in accordance with law. Yes. Dispose of.
Number 17, Partition.
What is that? Your colleague tomorrow.
Monday.
Not Monday. This is matter on 7th of November.
7th.
At the request of London Council Petition. Yes, next. Keep it in the file itself so that it will be easy. Yes. 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 This is matter on 24/10/2024. By the time husband shall pay before this court the receipts of fees paid towards education and other expenses. You have given her a copy of it. Please look into that tomorrow. As per the order passed by this court, the respondent has paid before the court the fee, the expenses that are borne by the father towards the expenses of the child. A copy of the same is given to the counsel appearing for the mother. She shall come up with the instructions when.
The Lordship, the interim order has been passed on 6/7/2024. Please today that the single gift has been not paid by the respondent.
We'll see. This is matter on 6th of November. Yes, next. Next. No representation on 14th of November. Yes, next. No representation on 19th of November. MC is disposed of. That counts for the petition submits at the way MC itself is disposed of. Nothing survives for consideration is with petition. Dismissed as instructions. Yes, next.
Number 78, number 79.
Yes.
The petitioner is mother's wife and her son.
Who appeals to the respondent? No representation for the respondents. This is matter tomorrow. Counsel for the petition is present.
6.
You wanted 6. 6.
Next week.
Why?
Sequence section. But my lord, sir, the respondent has filed the criminal petition before this honorable court, and the honorable court has granted the order of maintenance moving 14,000. Next week.
This is matter on 12th of November at the request of London Council petitioner.
12th November.
Please.
Number 81, CS Hireman. Hireman.
Your representation on behalf of either of the parties on 13th of November.
Number 82, K Party. Number 1.
I'm appealing for the petitioners.
Lordship, yesterday I got in connected to one more WPO among the cases. This posted on 6th November 24.
Post along with the so and so on when?
6th November.
Post along with so and so. Yes, give that number.
Meantime, and all. Copy of the petition may be served. Yeah.
Yes.
Petition, my lords. The respondent wife filed the petition under section 120 or 25 of CRPC, and thereafter concealing the fact that she had earlier filed the petition under section 125 with the again she has filed the maintenance under section 12 of Domestic Violence Act, my lords. And
She cannot file. She cannot file.
as per new judgment of Supreme Court, my lords.
She can file under section 12.
She can file.
Section 12, any relief under section 12 is in addition to the other relief she has. So, just because she filed under section 12 doesn't mean that she cannot have under other provisions of the other acts.
And my lords, earlier to the marriage, with the marriage, before marrying the petitioner, my lord, she had contracted marriage with another person, and that came to be, and she is the habit of grabbing money and
Only on the grounds. How much is granted?
that is not forthcoming.
What is not forthcoming? How much is the maintenance granted? That will be there in the order. That is what you have page number? Tomorrow, read and come. Yes, tomorrow at the request of counsel petitioner. Yes.
085, and come the disseminate on the staker.
One petition is filed by the husband and another filed by the wife, madam.
Which is filed by the husband.
106400.
10? First or second?
Yes, first, madam.
First.
Yes.
First is filed by husband.
Husband.
Second is filed by the wife.
Wife, for an answer. In this case, my lord,
How much is granted?
8,000 per month has been granted as an interim maintenance. Earlier to this, my lord.
You want enhancement?
Yes, madam. Earlier to this, my lord, the marriage was solemnized in the year 1997, my lord. Due to some misunderstanding, my lord, mutual consent was filed before the senior civil judge wedding in the year 2015, my lord. The matter was referred to mediation, my lord. There, at the request of the wife, my lord, the divorce petition was withdrawn, and once again, the husband and wife went for a lead to marriage life. That is only for 6 months. Thereafter, once again, the wife started quarreling with the petitioner as well as her family members, my lord. And one day, my lord, without informing any family members, my lord, she left the house of husband, my lord, leaving 2 children with the husband only, my lord. Daughters are there, my lord, 2 daughters, my lord. Thereafter, my lord, when the marriage was broken beyond this one, my lord, both once again filed mutual consent divorce petition before the court, my lord. And that was granted, my lord. My lord, by order dated 6/11/2019, my lord, it was granted, my lord. Thereafter, my lord, as per the conditions, my lord, she was given 7 lakh rupees as a permanent alimony, my lord. By accepting that, my lord, she has foregone all her future among this one, my lord. Thereafter, my lord, the wife filed appeal before the higher court, my lord, seeking for setting aside of the mutual consent award.
On the ground?
On the ground that, my lord, the decree was, the affidavit was in the Marathi language and she is not understanding Marathi language. Based on that, my lord, she filed appeal, my lord. But the appellate court has held that, my lord, since it is a tribal, since whether she knows the Marathi language or it is a tribal, but set aside the mutual consent on the ground that, my lord, no application for waiving of period has been, waiving of period.
She accepts that she received 7 lakh rupees?
Yes, my lord. In the decree, my lord, I have along with memo, my lord, I have filed, my lord, the order of the trial court, my lord, wherein, my lord, the court has specifically held, my lord. May I read the order, my lord?
No, you can tell the facts, yes.
Yes, my lord. She even she filed the affidavit before the court that, my lord, she has accepted the 7 lakh rupees, my lord.
And now what is that she wants every month? How much she want every month?
Now, my lord, in the 124 proceedings, she is claiming 1,25,000 rupees per month, 75,000 per month, my lord.
What is your income?
My lord, I am a businessman, my lord.
You cannot understand the contents, but money you can take.
No, that's the entire thing is disputed. And the trial family.
You have not even received 7,50,000.
No, I dispute that fact.
No, that must have been done before the Legal Services Authority. They will ensure that you take the check or how it is paid?
My lord, by through check, my lord.
They state that they have paid it through bank account. But my lords, may tell you, page number 129 of my petition, my lords, the learned family court that has observed regarding whether it has been received or not. It was transferred by one area distributor's account from the business account to the account and the
to your account.
No, not my account. That business is also run in my name. The business which he is carrying on is run in my name. To that account, he has transferred.
Check number, date that is mentioned in the in that.
She does not know. She does not understand Marathi words. That is the reason she had challenged it before the appellate court, and appellate court has rightly said.
Before the appellate court, what did she say?
My lord, she says that, my lord, she does not know.
Not about the language. What she says about the money?
She claims that, my lord, she has not received. But in the affidavit filed before the trial court, my lord, she has specifically stated even check number also, my lord. I have produced along with the memo, my lord. My lord, it is filed on 15th November 2023, my lord. It is in Marathi language, my lord. I have filed translated copy. Page number 11, my lord. This is the affidavit filed by the wife, my lord. In this, my lord, translated copy, my lord. In this, para number 5, page number 12, my lord, para number 5.
Page number?
Page number 12, my lord, para number 5, last para, my lord. May I read, my lord? It is decided that petitioner number 2 shall pay a sum of 7 lakh rupees as one-time permanent maintenance for my future livelihood. It is decided that said amount shall be paid me on the date of examination chief as appointed by this honorable court. Accordingly, today the petitioner number 2 has paid me the permanent aluminum white check number so dated 6/11/2019 for Rs 5 lakh rupees drawn on Union Bank of India branch Gadinglaj, and check number so dated 6/11/2009 for rupees 2 lakh. I have received both the checks and I have no grievance whatsoever in this regard. This is the affidavit filed by the wife, my lord, before the trial court, my lord, wherein the mutual consent, considering her affidavit, my lord, mutual consent.
No, where is that joint settlement or they must have appealed before the court?
Yes, I have produced judgment also, my lord.
Where is
it
that?
is in same, my lord, page number. First document, my lord, page number 4, it is in English, my lord. Actually, it is in Marathi language, I have translated it into English, my lord, page number 4. Before Honorable Civil Judge Senior Division Gadinglaj. Page number 4 or not.
In the very same
memo, yes, same memo. Page number 4. First para is, my lord, regarding the facts of the case. Second para. Both the petitioners have applied for Exhibit 8 to waive the condition of 6 months and their application is allowed. Today on 6/11/2000, both the petitioner have filed their respective evidence on affidavit as exhibits number 9 and 10, affirming their decision to obtain divorce, and have also filed joint process at exhibit number 11 to close their respective evidence.
What she will say about this?
Please.
When she has appeared before the court,
Yes, my lord.
what she says
She
about
says that, my lord, her signature was obtained through fraud.
No, court will ask the question, that's what it says.
Yes, yes, in the next para it is specifically stated. Heard the counsel for the petitioner. Petitioner were questioned, and it was confirmed from them in presence of their counsel that their decision of
No, she has questioned that. Where is that case? She has questioned that.
In appeal, my lord, it was mutual consent was set aside, my lord. Against that order, husband preferred appeal before the Bombay High Court, my lord. In that case, my lord, the appellate order has been stayed, my lord.
It is stayed.
Yes, my lord. Now, thereafter, my lord, she filed 125 for in maintenance, my lord. That's why, my lord, I am before you.
No interim order in this.
There is an interim order not to take any coercive step, my lord, since there was a
Interim order already granted is extended under further orders. This is matter after winter vacation. Can you write all the matters on the top of the list tomorrow? Remaining matters. There are final hearing are there? No, final hearing matters shall come on 12th November. Final hearing from 88 to 100 will come on 12th November. Part of matter will come tomorrow. On the top of the list it will come. And tomorrow morning, let me keep that specs here. Just have a check whether it is there or not.